Good afternoon, and welcome to the Appellate Division First Department. Most of you are regulars here, know the drill. I'm going to begin by the call of the calendar. We have requested more than 6 hours of argument time. So I'm going to ask you to please request the time you need, not the time that you want. Understanding that the court is fully familiar with the case, your briefs, the record, and oftentimes more than you wish we were. So, even when I cut your time, and I undoubtedly will, please know that the time clock is for you, not for my colleagues. So if you are so brilliant that my colleagues need to ask you more questions, I don't interfere with that. All right? Here we go. All right. People versus Robert Hinton. Oh, that's a first. Okay, so brief to me is 3 minutes and 2 minutes. Is that good? Oh, wonderful. Okay, so 2 minutes and 30 seconds. How's that? All right. Okay, this is the first. I'm gonna let them say what they. Yeah. People versus Jabon Walker. Okay. All right, I'm gonna do 5 and 2 and 5, and the arguments may take us to the 6. All right. Bayview Loan Servicing versus Danny Dalal.
Appellate requests 10 minutes.
Okay, 6 and 1 and 6. Angelica Escolastico versus Riggs Management.
Appellate request 5 and 2, please.
Okay. Okay.
Defendant respondents Millbrook and Riggs request 5 now.
Okay. 5 and 2. Building defendants 5. LTEC. I think your issue is a little 4 minutes. Okay. I like that better. 3. Okay. Thank you. All right. Thomas Orr versus Vornado Realty. Okay. Okay, 5 and 1 and 6. How about that? Okay. People versus Karan Richens. That's a submit. John Doe 18126 versus Young People's Chorus of New York City.
Defendant Appellate Children's Aid requests 7 and 3.
Okay.
6.
All right. So let's do 5 and 2 and 6. Star Indemnity and Liability versus Monte Carlo.
The appellant requests 8 and 2.
Okay.
6, please.
Okay. 6 and 1 and 6. Terrence Graham. People versus Terrence Graham.
Appellate request 4 and 1.
Okay.
Respondent request 4.
4 and 1 and 4. HMC Assets versus Simmer. You are the respondent? Okay, 2 minutes. All right. Schmidt versus the Board of Directors of Duane Owners. Okay. 5 and 1 and 5. Fishman versus Karen Isalis. Okay. 5 and 1 and 5. Alexis Travalia versus 135 West 52nd Street. Okay.
Good afternoon. Respondent requests 5 minutes.
Which respondent? Okay. Okay, all right, defendant 6 and 2, Crown 4, plaintiff 5. Ray versus Ray. All right, you're both getting 6 and 1. And Kuma versus Minks and Friedlander is a submit. First case on the calendar. People versus Robert Hinton.
Good afternoon, Your Honors. My name is Elizabeth Emmons. I represent,
Bring that mic closer
Yes.
to your mouth, okay?
how's that working? Is that good?
Yes.
Okay. Good afternoon. My name is Elizabeth Emmons. I represent Appellant Robert Hinton based on the People's Concession. I don't know what the court wants to do. They'll write a letter, I assume. I had prepared an argument, but I know you're well aware of my arguments. I wrote a brief and a reply brief. There was a case from the Second Department that came down yesterday.
But in light of the concession, we
Right.
don't need that, right?
Well, it is on all fours, in case you want to see it.
Yes, but this is not a court of record.
No, exactly, but I just
Okay.
wanted to let you know I would have argued that, but if they're
Thank
conceding,
you.
we're good. So
All
thank
right.
you very much for your time.
Thank you so much.
Good afternoon, Your Honors. Assistant District Attorney Saad Siddiqui on behalf of the people. Your Honor, as I indicated earlier, the people and defendant have reached an agreement in this matter, whereas the people will withdraw our opposition and consent to defendant's request for a reduction of his SORA registration level to level 1. Certainly, if the court has any questions, I am available to answer them.
Okay, please make sure that any written documentation of this agreement is sent to the court forthwith.
Yes, Your Honor.
Thank you so
Forthwith.
much. Have a
Thank you,
great
Your Honor.
night. People versus Jabon Walker. You may proceed.
Good afternoon, Your Honors. May it please the court. I'm Stephen Nemec here on behalf of Jabon Walker, and I'd like to reserve 2 minutes, which we just discussed. That's all right. Mr. Walker's seizure was unjustified. He was stopped based on conduct that was both lawful and, in context, unremarkable. He was seen crossing the street 2 hours after midnight on New Year's Eve, carrying capped, half-full bottles of liquor. Specifically, the arresting officer testified that he saw him carrying 2 to 3 bottles in his left arm as he walked across the street and then on the sidewalk. He could read the label on one of the bottles to confirm that it was a liquor bottle.
It was uncontested that the bottles, although unsealed, were closed.
Yes, correct. Yes, that
So
was
is it your argument that because there was a misapprehension of the law with regard to the open container law, that what happened here was invalid from the beginning?
Yes, exactly. I would say that the hearing court's conclusion that there was reasonable suspicion based on the possession of these closed containers because they were half full and had previously been unsealed is an error of law.
How does the additional facts play in that the officers one of the officers testified that they saw a weighted object, that object was pointing down, and that based on his training and experience that object was a weapon?
Yes.
And then there's an additional fact that he shone the flashlight on the jacket, and that's when the defendant ran.
I'll take those two in order. The secondary justification for the approach, this observation of a heavy weighted object on the right side of his jacket, possession of a heavy object by itself is not suspicious. The officer didn't describe that he saw a bulge. Like this doesn't get to a bulge case. He didn't say that the object had a shape. He didn't see an L-shaped outline. And when pressed on it, couldn't tell you which pocket he saw the object in. Later, after they tackled and arrested him, the gun's recovered from, he doesn't see him transferred out of his pocket, it's recovered from in between his waistband and the ground. There's an abundance of case law saying carrying something heavy can be a wide range of objects.
I agree that if the officer had just testified that it was a heavy object, that would be problematic. But here there's more, right? The officer testified that not only was it a heavy object, he testified that it was stiff, it ended out and pointed out to the ground, and then went on to say that based on his training and experience that he thought it was a gun.
Outside of the conclusory statement that based on his training and experience, he thought it was a gun, does he describe in any meaningful way this object that's weighted down, pointed downward, that in any way appears to resemble a gun?
He doesn't describe the shape of it at all. He describes, the observation he describes is the jacket. He says that the jacket on the right side was weighted down more towards the ground. So when he says it was stiff, ended out, pointed towards the ground, he's talking about the jacket. He doesn't see the object
And
itself.
to be clear, this jacket is a puff jacket for the winter time. It was black in the middle of the night on a dark street.
Yes, it's
Have I stated anything that is incorrect?
absolutely not. It's a yellow North Face. You could see it in the. It has those.
The yellow was limited only to the arms, am I correct?
Yes.
Okay.
Yes, exactly. And so the interaction between the specifically as to, I don't want to move past the whole idea of this shining the flashlight on the heavy object that prompted him to run, isn't really supported in the body-worn camera footage that we have. It's sort of a connection that's.
Well, did the lower court discredit that testimony?
The lower court did credit it factually. There's reason to question it, but what I want to say is the two observations in this case, this heavy object and the open container, don't interact in a way that amplifies the level of suspicion that you have. The most reasonable inference on these facts is he's carrying 2 or 3 bottles in his left hand. He's got something heavy in his right hand.
Well, let's put aside the bottle, because I think that we don't need that, right?
Yeah.
So if you concentrate on the heavy object, shining a light on it, and then flight, that totality does not raise to reasonable suspicion?
No, and there's a few cases that say that it doesn't. People v. Dalal is a case that says that somebody, he was clutching at a heavy object near his waistband, looked a little nervous and ran. That was level 1, and the flight alone doesn't get you to justify
I know that the testimony from the officer that based on his training and experience, he thought it was a gun. I know that could be deemed conclusory. I think I would agree with that. But that's what distinguishes this case from Diallo, right? In Diallo, there was no indication as to what the officer thought it was other than a heavy object.
That's true, but a heavy object could be the reason we have that you need to have a shape or an outline is because you can hold so many other things that are heavy that are
That's
range
true.
also.
Like a cell phone. A cell phone could be heavy.
A cell phone or a beer bottle or just about anything, right?
Or, yeah.
But that in conjunction with shining the light on it and then taking flight, put together, I grant you that individually, in and of itself, heavy object, no good, meaningless.
The combination with the flight, it's just flatly unsupported by the video. I know that the description was credited by the hearing court judge, but it's not there. I mean, this interaction, they single him out. They're driving in a patrol car. They U-turn around, and they more or less single out Mr. Walker.
Counsel, did Officer Delia give a running narrative of the video at the hearing?
They played the video. I don't remember it going like quite side by side. He's confirmed that the video matched his observations at some point.
So, counsel, what's your argument then? Is your argument that what the officer testified to is not supported by the video, or that if credited, it's still not reasonable suspicion?
I think even crediting it, it doesn't get you to reasonable suspicion. You have a heavy object, you have no shape, you can't tell which pocket it's in. The fact that he made that connection between I shined the light and then he ran, he's fleeing from what you have the basis for.
Does the officer say I shined the light on his pocket and I could see an L-shaped object which confirmed it was a weapon?
Absolutely not.
Did he say that?
No.
And certainly the video which shows a light shown into the street and then officers jumping out of their car and giving chase immediately.
Yeah, it's seamless, and the officers are jumping out. They're in uniform, but they're popping out of an unmarked patrol car. So, Mr. Walker's turning back into the flashlight, which covers a good 10, 20-yard space around him, and it sort of seamlessly escalates from come over here, and
Am
the
I
chase is on.
correct that the flashlight, when it was shown on the street, shows in the video that there are a number of men standing behind him against the storefront that is depicted in the video?
Yes, there are a lot of people.
Because it
around
is
that night.
New Year's Eve.
Exactly. And that's an important piece of context here. Where I think it's.
You'll have time on rebuttal.
Good afternoon, and may it please the court. Assistant District Attorney David Crowley for the people. This court should affirm the judgment below. And
Counsel, so saying that based on my training and experience it's a gun, you could say based on my training and experience it's anything I want it to be. That's conclusory, isn't it?
if all you say is based on my training and
What
experience.
else did he say other than it's heavy?
If I may, Your Honor, he described that it was inconsistent with innocuous objects that are commonly held.
He did not say that.
Yeah, he said, I believe he cited wallet, keys, and cell phone to say it appeared to not be, he thought it was a gun and it appeared.
Those are only 3 items, though, of an infinite number of items it could be.
That is true. If I may, though, can I clarify some confusion on the open container? Because it is not undisputed that this was a capped container. Nowhere does the officer ever say that this was a capped bottle. The officer says, I saw him with open containers.
Well, the reason he can't say that is because since he tackled him to the ground, the bottles broke, right? Yes, they broke when he was tackled to the ground.
That is correct.
So there would be no way after the fact to determine whether those were capped or not.
Right, and so if I can go, that is correct if you are saying that the only point he had to try and determine it was when he jumps out of a car and chases him, but that's not what happened here. What he sees is, on New Year's Eve, to Your Honor's point, this is the biggest drinking night in the town with the biggest party. He sees a man with what he describes as open containers, half-filled bottles, crossing the street in a public place.
Can we agree that if they are capped, there is no violation and no grounds to stop or interfere with his freedom of movement?
That's not the people's position. I think you can read the statute differently, but I don't think this court needs.
So on New Year's Eve, you're saying police officers have a right to interfere with the freedom of movement of New Yorkers anywhere in the city if they are carrying a bottle, whether they can tell if the bottle is open or not? That's
so
what you're
not
saying?
if it's a closed bottle that's never been opened. If you have,
that wasn't my question.
I'm trying to answer your question. Okay. If it is half empty and it's a liquor bottle, then they can come up and talk to you, which is exactly what this officer tried to do. I do think they can do that on New Year's Eve in New York City. If you're walking around with a bottle that's a liquor bottle that's half empty, I don't see why they couldn't.
But there's nothing illegal about walking around with a liquor bottle that's half empty.
If it's open, you are.
If it's open, that's the big if.
Right, and so there's nothing in this record to suggest that these officers didn't.
Didn't the court rule that the bottle was unsealed but closed?
No.
That wasn't the finding.
The
of the
suppression
lower
court did not find that it was capped. The suppression court referred to this as.
So why are we talking about this error of law if there's no finding that the bottle wasn't capped?
I'm suggesting that we don't need to talk about it. I'm suggesting that these officers.
But that was the basis for the intrusion in the first instance. And based on our case law, that is where we must begin our analysis. Whether at the inception of the intrusion, they were justified. So whether that bottle was capped is absolutely relevant.
No, of course. What I'm suggesting is we don't need to decide whether or not a closed but unsealed container violates the city code, because these officers didn't have to know that it was capped to get out of their car and try and find out. They just approached him having seen it. So let's assume they didn't know. Let's assume it's an open question. It's New Year's Eve. This guy's walking around with multiple half-empty bottles of liquor. According to the suppression court that credited the testimony, this officer just got out and asked to talk to the defendant. And then the defendant bolted. So to your point,
He has a right to bolt under our case law.
he has a right to be free of unreasonable searches and
He
seizures.
has a right to run if he does not want to answer the questions of the police officer.
The police officers, if they have level 3, and he or
And they
level 4,
didn't. They did not have level 3 here.
if they see a man, so the suppression court found that they had level 4 and level 3 based on the fact of these open containers. That is a finding of the suppression court, and it is reasonable, right? Because it's New Year's Eve, right? He's walking around with.
For level 3, don't you need reasonable suspicion that the person's engaging in a misdemeanor or a felony?
To act on level 3, right? So to detain him with nothing more, you are correct. Under 14050, you cannot detain and frisk him.
And having an open container is neither a misdemeanor nor a felony.
Correct, but they did not seize him. They did not detain him. They just went to talk to him when he fled. And when you take the
So the flight does what? The flight plus the open container elevates it to reasonable suspicion?
flight plus the no, it was at reasonable suspicion at the least, according to the suppression court, which is correct, or probable cause. Those are alternative findings by Justice Mandelbaum. But either way, if it's at level 3, the flight plus the object, which is, I agree, not as specific as other cases that do uphold guns, but all of that together means that it was not unreasonable for them to detain, right? And at the point that he's running away, that's why we don't know whether these are capped.
Counsel, how do you reconcile the court's holding in Diallo and Crawford,
Right, so-
based on the facts that you've just laid out?
So as I take these line of cases, if somebody's minding their business, walking the street, and
Like this
This
defendant?
guy,
not committing any other violations,
Like this guy.
like this guy.
He's walking with 2 closed bottles of alcohol.
On New Year's.
I would ask for any place in the record where it says that these were closed.
I would ask where it shows in the record that it was open, because it's your burden.
It's the testimony of the officer.
It's your burden, and that was not established. Even the court didn't find that.
The court credited the officer's testimony.
The court did not find that there was an open container, counsel.
The court did not find that there wasn't. And so these officers, the court never uses the word closed.
So the court didn't decide either way?
The court just uses the same language as the officer, that he saw, the officer says open containers, and the court refers to them as, at various points, they were half full and unsealed, open containers of alcohol, half full and thereby no longer closed and sealed, having been open and no longer sealed, an open container of alcohol. That's all quotes from the suppression court, right? So if he's walking around with those open containers, he is different than Dalal or Crawford or anybody else who's minding their business and just has a heavy pocket. These officers did nothing unreasonable in approaching him just to talk about the bottles. Maybe they say,
But exactly like Diallo and Crawford, the defendant there had an object in his pocket. The officer approached to request information, and the defendant ran.
right. And so if all that, sorry,
And the court suppressed.
because the defendant was not engaged in any other potentially criminal or violent.
So what was the potentially criminal or violent act that this defendant, this particular defendant, at the time that he crosses in front of the squad car with his bottles in hand, what is it that he's doing?
So I didn't say, I was saying violation. And the violation he's doing, which they have absolutely right to detain him to issue a summons, is he's walking around with open bottles of alcohol, and he is presumed to then
The officer had not seen the bottles were open. He saw him with bottles in his hand. The officer did not see him drink from any bottles.
correct.
He saw him with bottles in his hand. So he wants to know whether or not the bottles are opened.
No, he's testifying that they are open bottles, and he's concluding that in part because he sees that they are empty. He doesn't.
So then that's the problem, that the police officer equates open with a bottle that has been
Unsealed.
broken, unsealed, okay? But that's not what the law says.
So I
That's
think
not what the law says. It doesn't say, because plenty, and probably people in this courtroom, have gone to dinner, not finished their bottle of wine, had it recorked, and take it home. So what you are suggesting is that that creates an opportunity for police intrusion into the lives of people who happen to be carrying a bottle that is not open, meaning there's no top on it.
So what I'm suggesting is that if the officer, let's take this reading where they can't tell. They think it's a half-open bottle of wine that's uncorked, and all they go to do is talk to you. That's all they did. They did not.
So that alone is enough to then chase the guy?
If in the course of trying to see whether or not you have this open bottle of wine, a heavy object,
They shine the light in like less than a millisecond, because I watched the video. They jump out of that car and give chase. There is no hesitation. And you can't see anything in that video. Nothing.
So I have watched the video as well. I do agree that it happens fast. I think the suppression court correctly credited the officer that what's the officer's initial jolt is he's trying to get on the curb and step over a puddle, and the defendant bolts, right? It's clear that the defendant.
But you keep on saying that as though that's significant. The fact that the defendant runs does not elevate an encounter to a level 3 stop. It doesn't. It just doesn't. The law does not provide that. There must be more. And so if your officer had said, I shunned the light, and I could see an L-shaped object in that heavy-weighted corner of his jacket, then you would be 100% correct. That officer could shine that light, jump out of that car, and chase him.
So I will say that the law, I think the case law does say that flight, when you have level 2, flight brings you to level 3. When you have level 3, flight brings you to level 4. I agree that the cases where there is nothing except for a heavy bulge, flight does not get you there. That is the finding in most of these cases. But that is not this case.
All right. Thank you.
So hold on before I got to.
Please, of course.
So your argument then hinges on the open container.
I think that's probably right, yes.
Okay.
Thank you.
All right, I'll be brief. As to
After
whether-
that, you should be.
Yeah. As to whether it was disputed, as to whether they were capped or not, it wasn't challenged that they were capped in respondents' briefing. Basically, that the legal argument there relied on a definition of open that was just readily available, which, as has been discussed here, the hearing court's ruling that they were closed and no longer sealed, and that was enough to justify an inference is incompatible with the plain language of the law. So that's all.
Thank you. Bayview loan versus Dalal. You may proceed.
Thank you, Your Honors. May it please the court, my name is Harold Kaufman from McCalla, Raymer, Weber, Pierce, LLC. I'm here on behalf of the appellant, Bayview Loan Servicing. There are two issues that are before the court today concerning the statute, the Foreclosure Abuse Prevention Act, and specifically Section 203H. The first question is whether the statute was intended to apply retroactively or should apply retroactively. And the second is whether retroactive application would be constitutional. We argue that, well, first, these are both matters of first impression. We argue that this section of FAPA should not be applied retroactively, and that retroactive application would in fact be
Let's talk about that retroactivity, right?
Yes.
Section 10 says, this act shall take immediate effect and shall apply to all actions commenced on an instrument described under subdivision 4 of section 213 of the Civil Practice Law and Rules, in which a final judgment of foreclosure and sale has not been enforced. Was a final judgment of foreclosure and sale enforced in this case?
It was not, however,
Okay,
Section
so that,
10,
I'm,
of course,
right? Okay, so that means that this statute would apply to this case based on the plain language of the statute, no?
I disagree.
Why?
Because this case involves a deacceleration letter that was
That's
filed in
precisely the
2014.
point of the entire
No,
statute.
Because Section 10 does not address what was done before the statute. It does not address the 2014 deacceleration letter, which did not take place in this pending case.
It doesn't matter. It doesn't matter.
I understand that.
So-
In fact, this court specifically held in Genovese versus Nation Star that the statute did not expressly provide for retroactivity. It found it was implicit, that case is distinguishable.
You only distinguish
in this
it by
case.
saying it involves CPLR 213-4B.
Well,
I don't see the point of it. He does, or Genovese, does a thorough analysis of whether the statute should apply retroactivity, the whole statute. And so I don't see the distinction.
Your Honor, I know that you sat on Genovese, but with all due respect, I disagree with that. And the reason is,
Well,
Genovese
let's see.
involved
This statute was enacted to prevent lenders from surreptitiously restarting the statute of limitations time by de-accelerating something that has already been accelerated. So that was the specific problem that the statute was enacted to resolve. And here, your client decides to send a letter saying that we are writing to you to advise you that we have de-accelerated the loans, and it just happens to be 2 months before the 6-year statute of limitations expires. Seems to me that this is precisely the kind of case that the statute was intended to prevent. So explain to me why it isn't.
Okay, I disagree. First, there's nothing explicit. Second, there's
Nothing
defense
explicit in what?
in the statute saying it applies retroactively. There's a high bar.
You keep saying retroactive. I'm not using that word. The only one using that word is you.
Well, in
We have
order
not
to,
said that it is retroactive.
you cannot find that the deacceleration, or you cannot grant summary judgment for appellant unless you find retroactive application.
That's
You
not,
have to-
counsel, that's your argument? That is not an argument that has been accepted
Well,
by this court?
this court has found that in Genovese that it had to apply the statute retroactively to apply 2013-4B. Plaintiff here, or defendant rather, is seeking to apply 203H, which did not exist at the time the deacceleration letter was sent, did not exist at the time that this action was commenced. Most importantly, it didn't exist, as I said, at the time that the letter was sent. At the time the letter was sent, we had every right under 100 years of case law.
Had you perfected and obtained a final judgment on this action prior to the enactment of the statute, you would be fine, correct?
Yes,
Correct?
but
So there would be no retroactive effect on your case had you had a final judgment, as the statute says.
however, we didn't have to at the time we sent that letter. At the time we sent that letter, the deacceleration notice
So
was
you
valid
suggesting
over
are
100
you
years.
suggesting, counsel, that new legislation cannot be enacted that is enacted for the purpose of righting a what is perceived by the legislature as a public policy wrong?
Of course it can. However, it can only apply prospectively unless you find a basis, unless there's some basis for retroactivity. This case does involve retroactivity. You
Okay,
cannot.
you'll have time on rebuttal to continue that argument.
Thank you, Your Honor.
May it please the court, Jonathan Warner of Warner and Shoreman for Link Point Realty. Your Honor has hit this case precisely on the head. It's not a retroactivity case, and if it were a retroactivity case, this court's decision in Genovese versus Nation Star would certainly decide the issue. But I want to address issues that the appellant hasn't addressed, and specifically, I want to address the argument that they make that this was a taking or a taking of a contractual right. Specifically,
Right. You
What
say that the-
provisions give him that right? I'm sorry.
I'm sorry, Your Honor.
What contractual provisions give him that right?
None. And that's exactly the point. There's no provision in this mortgage saying we can reset the statute of limitations. Nothing. In fact, the statute of limitations isn't even addressed in the note and mortgage. That's the important thing on the contractual analysis. There isn't any contractual provision in here. And I
But
might add-
they make the point that it circumscribes their ability to foreclose, and so that was a right they had under their mortgage contract.
Well, they really didn't, Judge, because the right to reset the statute of limitations is not a 100-year-old right, as my adversary would indicate. It was really developed out of the Knoxville case, and then the Court of Appeals in Engle decided it, which was long after this mortgage was originated. This is a 2007 mortgage that's accelerated in 2009. In 2014, when they send a, quote, de-acceleration letter, this right, as they claim, didn't exist. And moreover, I note that FAPA doesn't prohibit, it just doesn't prohibit revocation of acceleration. And that's the point that these banks are trying to get Your Honors to bite on. It doesn't prohibit de-acceleration. A bank can accelerate, de-accelerate, and accelerate and de-accelerate all at once. It just doesn't have the right to reset the statute of limitations. And that's a right that no plaintiff has in this state other than under their argument that they have this right. Now, with respect to this argument, I know in other cases, because this litigation is going on in the second department, they've held this statute to be applicable
retroactively in U.S. Bank versus Races, which is 2283rd 907. And in the Second Circuit, they recently certified a question to the Court of Appeals in a similar situation, asking the Court of Appeals, but I want this court, and they claim that somehow the use of the word shall in FAPA means that it's supposed to be prospective only. I might add that in this provision, unlike other provisions of FAPA, there's no use of the word shall. In 203H, it says no party may reset the accrual of the statute of limitations unless it's done in accordance with GOL 17105. This is not an issue of prospective and the use of shall, as Your Honor correctly states. This is an attempt for remedial legislation to correct a singular circumstance, namely the power of the banks to reset the statute of limitation unlike any other plaintiff in this state. And the legislature said, no. You have 6 years, and by the way, with respect, Your Honor, to the contractual issue, there are other contracts that have internal statutes of limitations that are different from the 6-year statute of limitations and mortgage foreclosure actions. Many insurance contracts have 2-year statute of limitations, and other agreements are self-regulating at a lesser amount. If this bank really thought that this was an investment-related decision, they might have had a provision for a longer statute of limitations in their contract. That was not done here. In fact, the statute of limitations isn't addressed at all, so it's not a contractual taking. That we know. Then the next question I think that Your Honors need to look at, is it a categorical taking? Under the analysis of Gleason and other cases in the area of constitutionality of quote-unquote retroactive application. And it's simply not. All the court did here was apply the legislative direction to remedy the situation that really arises out of Knoxville and Engel that allowed the bank to reset the statute of limitations unilaterally. And what the legislature did and said was, no, not unilaterally, you can do it bilaterally under 17105, which had always been the law in this state. In fact, if you look at the history of mortgages, the only party that could reset a statute of limitations was the borrower by doing various things to pay off the outstanding balance when he owned the equity of redemption. Anyway, if there are any,
less than 10 seconds left.
I'll waive my 10 seconds.
Thank you. And you have 1 minute, sir.
Yes, first, with respect to the language speaks in the future tense. It's may not. It's not that you can't go back, that we're going to go back and say what was legal and what was entirely permissible for 100 years before is no longer good. It says may not, going forward, has nothing to do with what happened in 2014. As to constitutionality, the case law, we've cited cases that have held it to be unconstitutional. It clearly deprives a lender of its right to foreclose, which it had on 2014.
No, it didn't. You had a right to foreclose. You had an action to foreclose that you did not act upon and prosecute on time, and then you tried to set the clock anew.
With all due respect,
that's what happened here.
With all due respect, we had every right on the law that existed in 2014 to de-accelerate and then to commence a new one. It was done every day, and the legislature, without holding a hearing, without even considering the impact of its actions, decided or drafted this, and it's being held to apply retroactively. It should not apply, and it is not constitutional to take a right that we had in 2014 when we de-accelerated and strip us away from that and hold that we have lost our mortgage, which was here $472,000, in favor of a party who paid nothing and who who bought this from the borrower, who's not even the party who's protected by the statute, while we paid taxes. And
Thank you.
You're welcome, Your Honor. Thank you very much.
Thank you. Escolastico versus Riggs. You have 5 minutes.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff appellant. I'd like to start off by saying that the trial court erred in finding that the expert, Mr. Karajat, was not qualified to opine in this matter. As you can see in our brief, he's been an expert in numerous cases, and in a particular case in this court as well, he was recognized. It wasn't the issue before the court.
We've never found him to be unqualified, right? We may have impugned his opinions, but we haven't found him to be not an expert, correct?
That's right. And as you know, it goes to the weight of the evidence and non-admissibility. So I don't really want to spend a lot of time on that. I'd like to move to the merits. With regard to the merits, it's our position that there is notice for both Millbrook and LTEC with regard to plaintiff's complaints of what happened on the day of the incident. As you know, plaintiff's in the elevator, and it goes up, stops at a floor for a while. It stops abruptly. She hears a noise. And then the next thing she knows, after 15 minutes, she calls her daughter. It abruptly falls with another hard impact to the lobby. The records, I mean, it's just replete with of work tickets from LTEC regarding jumping and shaking. That was at 1676 of the record.
That's the only one, though, that you guys point to, and that was 15 months prior to the accident, that talked about a similar motion of the elevator as it, allegedly caused the accident here. The other tickets don't seem so apropos. Correct me if I'm wrong.
Well, they're not precisely that, but they're similar in this regard. So 3 months before the incident, LTEC was there for a faulty drive. And Mr. Castro and Mr. Parvis, who are representatives of LTEC, explained that the drive affects the motor and the drive affects the speed. It allows the elevator to go up, and then it regulates the speed as it's getting to the floor. So that would go towards the precipitous drop and the sudden drop of the elevator.
Let's put notice aside for a moment. Don't you agree that liability requires showing one of the Espinal factors? Because you don't really emphasize that in your brief. I don't think you cite Espinal. Espinal versus, you cite a different Espinal, but you don't cite the one about, the important one about launching an instrument arm, et cetera.
Of course. It's our.
Don't you need one of those factors?
For LTAC, if.
Yes, for LTAC, because they have a contractual relationship with the building defendants, so why do they owe a duty to the plaintiff?
Because under Rogers, it's our position that they have an exclusive maintenance contract and repair contract that's at 1245 of the record with Millbrook, and it's responsible for the motor, the controller, the very things that are the subject of many, many work tickets.
No, but it's a grease, whatever they call it, a grease and lubrication contract or whatever. It's not a comprehensive contract.
And we've had them, so we're quite familiar with the language of those. And this is not that.
Okay, well, if you don't find it to be direct, then I would have to establish Espinal. And if it's not in my brief, I can't talk about it today. But our position is that they're directly have a direct duty to the plaintiff because it is an exclusive contract. It's the only company that was responsible for maintenance and repair. And if you look at 1247 of the record, they were required to regularly and systematically examine and inspect and repair the parts of the machine, like the hoist motor, the controller, the brake, the very things that the repair tickets reflect and talk about with regard to the door operating. So our position is that they have an exclusive contract. And so therefore they have a direct duty to the plaintiff. Can I talk about Millbrook? So with regard to Millbrook, There's evidence that the plaintiff complained to the super, to Noella Villalis at the building, and there's also evidence, as I said before, between the jumping and the shaking and the faulty drive. There's also evidence that the door operation is directly related to the operation of the elevator, which
So there's an issue of fact as to whether they had noticed.
Yes,
Building
and-
defendants.
Yes, and there's many maintenance tickets and building dispatch records that show that. I want to point out one important thing until my light goes on, is that the LTEC was apparently there on the day of the incident, on January 4th, 2017. Except the problem with that is that, and this is a building log at 1282 of the record, it shows that they were there on 1/4/17, but there's no work ticket, there's no dispatch statement. Mr. Castro, who is the representative from LTAC that apparently went there, does not recall what was done on that day. That was prior to this happening. We don't know the condition of the elevator at that time. That's not in the record. Should I wait to reply?
Wait for Ruth.
Okay, I'll come back and reply. Thank you.
Okay. Sure. You're the building defendants, right?
Yes. May it please the court, my name's Antigone Zakis. I represent the respondents Millbrook and Riggs, the building and property management company. This case is very simple. This accident could not have occurred, as the plaintiff alleges, in whatever version you choose to
There's
believe.
a dispute about that between the experts. So if we find that the court improperly disqualified plaintiff's expert, why is this not then an issue of fact?
That's the thing, he's not an expert. That's the first.
And again, I say, if we determine that he was improperly disqualified, right? Because we have never disqualified him.
Yes, Your Honor.
As my colleague said, we may from time to time take issue with some of his opinions, but we haven't disqualified him. And whether we agree with his opinion or not, his opinion is vastly different and specific with respect to the allegations raised by your expert.
Yes, Your Honor.
So why is that not a quintessential issue of fact? We can't determine that.
Your Honor, it's not, because it's not supported by any evidence in the record. The first thing that their supposed expert does is just ignore the fact that the plaintiff gives markedly different testimony in her deposition testimony to what she tells the ER doctor.
He points to a completely different, look, whatever she told the ER doctor, as far as I'm concerned, is probably not even admissible. Because unless those statements were relevant to diagnosis and treatment, they're hearsay. So let's put that aside, okay? There's well-established case law on that, all right? So the issue really is whether both these experts opine differently about what the mechanism of the problem was on the elevator. And they do. They do. Completely different. So how can we determine which one is right? I think that's what you're asking us to do. To say your expert is right and her expert is wrong. When have we ever done that?
Well, one expert has support in the documentary evidence provided by LTEC in terms of their maintenance and service records for this elevator.
So tell me, where's the missing ticket for the service that happened after this accident? All it says is it was service. It doesn't tell me what was service, what was wrong with the elevator. Something happened. Something was fixed. We don't know what. Why is that not a blaring issue? A fact.
It's not because we have the testimony of Rigoberto Castro, the mechanic who is there servicing the elevator, saying that there wasn't an instance where the governor, which would be the thing that's controlling the speed of this elevator, being tripped in any way that day. Or
did he contradict the fact that if there's something wrong with the drive, if the drive is malfunctioning, that too impacts the speed by which the elevator moves? Did he contradict that? I don't remember seeing that in response to the plaintiff's expert's report.
The last time there was any issue with the drive, I believe, was October of 2016, which was close to 4 months, 4.5 months before this incident. And there's nothing in these records, service or maintenance records, since then that points to the drive being at all.
That wasn't my question. My question was whether your expert controverted the opinion of plaintiff's expert on this issue.
What our expert, Your Honor, says is that this could not.
On reply, he has an opportunity to submit a further statement saying what that expert said, and they took great pleasure at saying he's not an expert, he's not even an engineer. But I don't remember seeing them specifically saying anything about his particular factual statements.
Your Honor, I just have to point back to the fact that the drive is not what was the issue here. The controller is what would be guiding the speed and preventing the elevator from having the drop that plaintiff claims.
So does your expert tell me, I'm gonna give you one last chance, does your expert tell me that the drive does not impact the speed as plaintiff's expert said? Does he say that anywhere? Because if he did, I'm sorry I missed it.
I do not believe so, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Good afternoon. Edward Tobin, Gallo, Vitucci, and Kalar on behalf of LTEC. Your Honor, if you will look at the rebuttal affidavit of LTEC's expert, Mr. Halpern, he did rebut each of the conclusions reached by Mr. Karajat. And as the lower court definitively determined, none of Mr. Karajat's opinions would indicate any negligence or any wrongdoing on behalf of the defendants. The accident occurred—
On behalf of LTEC?
On behalf of LTEC.
Okay.
And the lower court was correct, and it truly adopted both defense experts' conclusions that if the accident occurred as the plaintiff described it, some type of free fall, there's a mechanism called a governor, which would have been triggered, and that would have stopped the speed of the elevator and allowed it to descend at a normal rate of speed. That did not happen here. That indicates that governor was never triggered. Also, with respect to the drive being replaced, if you look at the testimony of Mr. Purvis, he actually did testify that he did replace the drive many
Counsel,
months.
what about the ticket? Was the ticket from the day of the accident, or was it from the day after? Was there one for the day of the accident?
There is a missing ticket with respect to the day of the accident.
It's a missing ticket.
Well, yeah. The records indicate, and I will concede to plaintiff that Mr. Castro from Realtek did appear on the day of the accident.
And
The super said that, right?
And he was unable to recall what he did on that day.
But that has
We have no
bearing.
ticket and a worker who can't
Well, that's-
recall what repair he did.
That's not preserved in the record, and also
Sure it is. I read it in the record.
well, that has no bearing on the cause of the accident or on Realtek's negligence and whether anything Realtek did prior to the accident caused or contributed to the accident. And with respect to notice, my final point, Your Honors, there's no evidence of any prior notice to.
Keisha Espinal, the plaintiff's daughter, and the plaintiff both said that they complained to the super about the elevator.
Complaint to the super, there was no complaint made to Realtek, and based upon the limited provisions of the contract between Realtek.
And the work of LTEC was prompted by notification by the building owners, correct?
Following the incident, yes.
No, I'm saying generally, so that,
Yes.
right?
Yeah.
If there was a problem, LTEC
Yeah,
was called, they came to they serviced the elevator, et
Yes.
cetera. They
Yeah,
weren't
LTEC,
on
yeah.
site every day.
Yeah, exactly.
LTEC didn't agree to assume and displace the building owners,
Exactly.
correct?
Exactly.
Thank you.
Thank you very much, Your Honor.
The issue of what happened on January 5th is critical, and that's at 1275 of the record. There is a missing work ticket, and here's why. Mr. Betances from the building admitted that when he opened the door and plaintiff is sprawled out from being injured from an elevator, he didn't think anything was wrong with her, so he didn't tell Velasquez to call LTEC until the next day. That's why there was nothing that went on January 4th. January 5th, the next day, is when LTEC came back and creates a dispatch statement which only says secure controller and operator connections. He doesn't remember what that means. The defendant's experts, neither McPortland nor Halpern, addresses this entry and connects it, or it's their burden, or fails to, or says this has no bearing on what happened the day before with regard to the incident with Mrs. Escolastico. So that was their burden to do that. And so all we
I'm
have
sorry,
is this.
what follows from what you just said? I didn't quite follow the argument.
I'm sorry?
It may be me, I don't know. What follows from the fact that the ticket was as you just described, the January 5th ticket?
Why is that important, you're saying?
Yeah. tell me.
Because this is what they did to inspect the elevator from the accident. It wasn't done that day because Mr. Betances didn't think anything was wrong, didn't think anything was awry. He admits that in his deposition. I didn't call LTAC. I didn't do an inspection of the elevator to see what would have happened, why this happened, because she was fine. He admits that in his deposition. So they come the next day, and this ticket, there is no ticket for January 5th, but there's a dispatch statement which has a remedy for what they did, but they don't connect it to, or have a lack of connection to what happened to the plaintiff the day before. And the last thing that's telling about this entry is this secure controller and operator connections is exactly the same thing on the trouble call from the year before, which is at 1263 of the record. The same thing was found the year before on a trouble call. And so the fact that they didn't establish that, it's their burden, and they didn't meet it. So I would ask the court to reverse.
Thank you.
Thank you very much.
Orr versus Vornado. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court. Jack Lockwood for the plaintiff appellant. This is another elevator case, Your Honors. Another defendant's motion. I'd like to emphasize again that the plaintiff is entitled to the benefit of all favorable inferences, no credibility determinations. The trial court here erred in granting defendant's motion for summary judgment. It determined that plaintiff's testimony was incredible as a matter of law. That was scientifically impossible, all of it, I think. And so the court refused to consider any of it. Plaintiff worked as a freight elevator operator and a porter in this building for 15 years. He worked in this exact elevator, elevator number 22, for 15 years, 8 hours a day, taking freight and passengers up and down the 39 floors of this building. He had a lot of experience using this elevator, and he knew when it was not.
So let's talk about the OHR report, because the court explicitly found it to be inadmissible, hearsay, but then did allow the expert to, for the other side to rely on it. Now you take issue with that.
Yes, Your Honor. We think that the expert should not have been considered because the court erred in concluding that the the online history reports that were prepared by Otis were admissible. The plaintiff objected to the admissibility under the business records exception.
Did the Goritsky affidavit fix that?
I don't think so, Your Honor. The court didn't find that affidavit laid a foundation. It found that it was actually just remedying basic deficiencies in the initial motion papers. Then it found that the expert could rely on out-of-court statements under two exceptions. It found the second exception applicable, finding that the affiant could theoretically testify at a trial. Of course, this was in the same order that the court dismissed the case.
That's never going to happen.
So it would be impossible for this gentleman. He didn't testify at an EBT either. So plaintiff had no opportunity to cross-examine this witness. I think if you trace that exception back, the Court of Appeals first enunciated it in a criminal case. Of course, there's no summary judgment in a criminal case. It's a much sort of different situation. We think the court misapplied it here, and that the defendant's expert should not be considered because his opinion was based primarily on the online history report. If you do look at the online history report, and even if you do look at their expert's affirmation, there is lots of notice here. There are lots of problems with this elevator prior to both of the dates that plaintiff was injured. He was injured on August 21st. He was injured on August 28th. As early
He
as...
complained in that same August month, right? The same year, 2014.
That's correct. He testified that he complained numerous times. He complained to the supervisor and the foreperson, Ahmed and Sonny. He complained to Owen, the security guard who worked there. They made written reports. And they took action. The tickets show that they, on May 23rd, they was stopped in flight and then it resumed. They mechanically adjusted the controller and the direct drive. May 27th, they get a fault code on the drive fault. The elevator shuts off. They have to reset the drive. August 21st, same day that plaintiff was injured, before plaintiff's accident, they have to replace something called a P coil. Later that day, plaintiff's injured. They do have someone come to the site, and they don't find anything wrong with it. They actually take this elevator out of service on September 19th. So that's about 18 days after the plaintiff's second injury. And the reason they took it out of service is because Otis's on-site mechanic actually experienced the same thing that plaintiff was actually experienced a stoppage in flight. That same day, they took it out of service. They left it out of service until they fixed it. And it took them weeks to fix it. And eventually they did fix it. And the problem was an MR relay or something like that, which the defendant's expert says was unrelated to anything that the plaintiff was complaining about. Our expert and even their expert says it's connected to the drive, it's connected to the control unit, and could cause these abrupt stops which cause plaintiff's injury. I just would like to touch briefly on the plaintiff's expert. As in the prior case, it's the same expert. He has much experience in this industry. He's published numerous publications. He's
We've never said he's not qualified as an expert.
correct, Your Honor. It should go to the weight, not the admissibility.
Thank you.
May it please the court, David Paul Horowitz for Otis Elevator Company. First, just on the issue of the expert, I agree that this court has not found him not to be qualified. I certainly searched, but that doesn't mean that this court has previously examined and lower courts have actually dealt with the issue of whether or not he was qualified. In fact, what happened
How many
here
times
is
has
that-
this expert testified in court?
I'm sorry?
How many times has this particular person testified in
Oh,
court?
it's in excess of 100. However, on numerous occasions, I forget whether it's 27 or 37 currently, his testimony has been found to be speculative and not supported by
And
the
that's
record.
for the jury to decide.
It's a matter of credibility.
Well-
How much weight will they give his testimony, given the fact that he doesn't have a engineering degree and that at times his testimony has been found to be speculative? So that's something for the jury to determine.
Well, I think the court, the motion court in the first instance can dismiss an expert's conclusions and opinions when they're based on speculation, as Otis contends they were here.
But he doesn't. And so since we're not elevator experts, right?
Nor am I.
Right, so what we have are 2, 3 sometimes different experts giving us their opinion, and which is why our case law generally finds that it's not an issue of admissibility, it's an issue of the weight that the jury can accord it. I would suggest that you utilize the rest of your 4 minutes on another issue.
Thank you. The only thing I will say is Justice Getz did actually, after finding that Mr. Carriger was not qualified, go on to say, but in the event that he were qualified, and we consider his testimony, it is speculative. And that's what this appellate court does many times. It will consider the expert's credentials, say that an expert, this happens in medical malpractice.
I think that on a case such as this, where your plaintiff was the elevator operator for the elevator in question,
Correct.
I think you are streaming uphill, my friend.
Okay. I need
Okay.
the exercise.
All right.
What I would turn to then is
Touche, I like that.
what I would turn to then, Your Honor, is the alternative theories that Otis advanced, the impossibility. And what's interesting is that Mr. Belmar testified about 2 separate incidents on 2 separate dates, almost to the identical set of facts. And they included, or I'm just summarizing, the elevator ascending, descending, stopping, lights flickering, ascending again, and then finally descending, at which point the elevator came to a stop. Mr. Carriger acknowledged that that isn't what happened. That can't happen. We have an impossibility argument. So what Mr. Carriger did is take one of those facts, really talked about the final descent, and say, well, the elevator descended, it descended quickly, and that was ultimately the result, he says, over and over, of a defective drive. Now, again,
with regards to the impossibility, in the line of cases that we deal with impossibility, in those cases, it's found that the elevator continued to operate normally, right? And here, eventually there was a defect found in that elevator, right? A loose piece of solder or something. So doesn't that take it out of the impossibility realm?
Well, you're absolutely correct. There was a defective component, but I don't think it takes it out of the impossibility argument. Again, the fact of the matter is what Mr. Belmar described.
But who can say if there is a loose piece of metal floating around in the compartment mechanism that operates this elevator, who's to say that at any point that loose piece of metal did not make contact with an internal mechanism that caused exactly what the plaintiff said?
Well,
who's to say?
I would say that we concede that that loose piece of metal, the loose piece of solder, did in fact cause the operation of the elevator to be interrupted. We don't dispute that. What we say, and is borne out by the test, we had a resident mechanic who worked 5 or 6 days a week in that building since at least 2007, who was intimately acquainted with all of the equipment. What we say is that defect, which was in a sealed relay, and that sealed relay, it's basically like a light bulb. You don't service it, you don't maintain it, it's sealed, you can't get access to it. It's like a light bulb. When it blows, you replace it. Because of this loose piece of solder, we have what's called, we refer to as an intermittent stoppage of flight. When that loose piece of solder would move, it would cause the elevator to stop. But that's all it would cause the elevator to do. And I want to go back to the issue.
Yes, but you say that as though there is some controlled way that that stop occurs each and every time.
There absolutely is a controlled way that the elevator stops. Because
not with a loose piece of solder floating around in the mechanism.
No. And I didn't mean to suggest
And so that's what I'm saying, that quite frankly, and I'm speaking only for myself, not for my colleagues, but if there's a loose piece of metal inside a mechanism that when it touches the wrong mechanism causes the elevator to stop, that's not something that is normal. That's not something that we can say we have a sheet of what normally happens when this happens, because this ain't supposed to happen. So it seems to me like this is an issue for experts and a jury to decide.
And I'd like to respond. I know the light is on.
I will give you 30 seconds.
Yes, it did happen, and it does happen that way. The issue is that it was undetectable. But when that fault in the MB relay causes the elevator to stop, Mr. McPartland was very clear. The elevator comes to a sliding stop. Mr. Carriger alleges that the elevator oversped. And you heard in the prior case, overspeeding, if it occurs, trips a governor. And that governor then has to be reset by the mechanic. Each time Ms. Vasic, the same overnight technician, responded, there was nothing that needed to be reset. Again, because it was an intermittent, undetectable problem. And Otis's argument—
Got it. Thank you.
Thank you.
Your Honors, there was a defect here. They did find a defect. The sliding stop testimony was talking about when the governor was engaged. It's uncontested that there was stoppage of flight that was going on before, during, and then after the two accidents that happened here. And when Valerio, Otis's resident mechanic, actually experienced stoppage in flight, which is what he called it, he immediately took it out of service. And it should have been taken out of service before, because they had adequate notice of these problems with the drive. And the thing that they eventually found was a problem with it, the MB relay, is associated with the brake. So it all fits together. There are tribal issues of fact as to whether Otis had knowledge of the problems of the brake and the drive, whether they failed to exercise reasonable care to discover and correct it. They actually serviced the elevator in response to these prior complaints. That raises a triable issue of fact on notice. And the jury may infer actual notice and negligent inspection, negligent repairs, where the defendant conducted regular inspections. Thank you, Your Honors.
Thank you. Doe versus Young People's Chorus. Justice Mendez is recused from this case. Should there be a tie, the court will follow the Appellate Division First Department's rules on vouching. You may proceed.
Good afternoon, Your Honors. My name is Steve Sinico. I am with Cohen and Gresser LLP, and it's my privilege to be in front of the court this afternoon on behalf of Defendant Appellant, the Children's Aid Society. To the extent I don't address all the arguments Children's Aid's put forward in this appeal, Children's Aid's not waiving those arguments. We're resting on our papers.
Of course.
This case is before the court on a motion by Children's Aid to dismiss plaintiff's verified amended complaint pursuant to CPLR 3211A5 and 3211A7. The disposition of the motion turns entirely on straightforward application of express provisions of the CPLR, well-settled case law of this court and other departments of the Appellate Division.
Counsel, one pleading motion case by us that you don't cite, and I don't think the plaintiff does either, is SCH-MG-25 Doe versus Archdiocese, but it really was against the New York Athletic Club. Are you familiar with that case?
I'm not, Your Honor.
The pleading was similarly bare bones. I'll characterize it that way. And I agree with you that the pleading here was bare bones. But because of the age of these alleged incidents, we did find in that case, and we often have found, I believe, that the information might be in the possession, more likely, of the defendants. And so therefore, if the elements of the causes of action are pleaded, even conclusorily, we let it go forward. So tell us why we shouldn't do that in this case.
Well, Your Honor, the reason that it shouldn't happen in this case is because there are facts of a type that would typically be within the knowledge of the plaintiff that could be alleged, and none of that was done here. For example, there's no allegation in this case that the plaintiff ever told anybody at Children's Aid, or indeed anybody in the world, about what allegedly happened to him at any time before he commenced this action.
So you'd have the plaintiff say up or down whether they told anybody in the past? Because, I mean, one could imagine that a child would, not tell people about this.
Yeah, that's not unusual. That's the reason we have this statute.
Well, of course, Your Honor, but the point here is that notice of propensity is unquestionably an element.
I know, but when you start that argument with, but the child didn't say anything, that is, it's like deer in headlights. You're missing the point. The whole point is that children do not feel safe to say.
That may be true, Your Honor, but that may well be true, Your Honor, and that may well have been one of the reasons that the Child Victims Act was put into effect, but it doesn't go to the point. In other words, the Child Victim Act permits an exception from the statute of limitations. It does not permit an exception to pleading standards or to the standard that to the elements of the cause of action, one of which is notice. So there's no question that there is no allegation in this case that the plaintiff ever told anybody about any of this. That's one point. Second point is that there's no allegation here that there were any witnesses to this alleged abuse.
Typically, there are no witnesses to child sexual abuse.
That's not necessarily the case, but there are no such
I would say
allegations
99% of the time when there is a child sexual abuse situation, child sexual abusers don't sexually abuse children in front of other people.
Understood, Your Honor, but
Okay.
again, it goes to the question of notice. Advance notice of a propensity on the behalf of or on the part of the alleged abuser is an element of this claim. Failure to plead that element calls for dismissal, exactly as happened in Easterbrook's, Doe versus Hop-Hog, Fuller, and numerous other cases that we've cited to this court, including Nagley and Hammond. There's ample case law for the idea that conclusory notice of propensity allegations are insufficient to survive a 3211A7 motion to
Did you have filed the bill of particulars?
Your Honor, it's not up to us to file. It's not up to us to file a bill of particulars.
Doesn't the plaintiff have an opportunity to amplify their complaint through the filing of a bill of particulars in our precedent on this issue.
That could well happen if the complaint is legally sufficient, but our point is under Nagley, Hammond, Easterbrooks, Fuller, Doe versus Hopog, the complaint is not legally sufficient, and it should have been dismissed on that basis. There is another ground for dismissal here as well, which is CPLR 3211A5, and the fact that the plaintiff didn't, again, the statute is very clear. CPLR 214G says that claims based on allegations of child sexual abuse are revived, and they may be commenced not earlier than 6 months after the effective date of the statute, and not later than 30 months after the enactment of the statute. Here, there's no question that plaintiff didn't do that. Plaintiff didn't commence the claims here until over 14 months after the CVA.
Because they had to move first. They did move. They didn't have to move, but they did choose to move. And the court didn't act on it timely, so what are you going to do if you're a litigant?
The answer to the question, Your Honor, is that there were ample opportunities for the plaintiff to take steps and to assert these claims.
Yes, but we don't prejudice a plaintiff who has an otherwise proper claim before the court to consider, because the court's ability to get through all of the motions filed before the court. So we're not going to hold that against this plaintiff.
Your Honor, this court's decision in Singer holds that the look-back window in a revival statute is a condition precedent, a legislatively established.
So you're saying that the court can assist in preventing a plaintiff from being able to meet their statute of limitations by not deciding a motion that was filed prior to the statute of limitations on time?
Not at all, Your Honor. It's the obligation of the plaintiff under the statute.
So are we correct that it was filed timely and that the decision of the court took it over the time?
A motion for leave.
Is that correct?
May I finish, Your Honor?
Is that correct?
The answer to your question is that a motion for leave to amend was
No,
filed.
that's not the answer to the question. My question was, did the court decide the case after the statute of limitations, thereby enabling this argument, but the plaintiff filed the motion on time?
That is not, Your Honor. First of all, yes, Your Honor is correct that the motion court did not decide the motion for leave to amend until after the CVA window had expired. But under this court's precedent, under Singer, the compliance with the legislative created look-back window in CPL 214 is a condition precedent that is not subject to judicial tolling. So the notion that the rule here is the plaintiff has to get his claim in on time. This plaintiff in particular had...
Counsel, that issue's before the Court of Appeals, correct?
You know, Your Honor, there is a case, Jones versus Cattaraugus, that's being argued in the Court of Appeals next month.
November 19.
I don't believe it actually is going to address it. We don't know. It doesn't actually address this question. The question in Jones is whether where the plaintiff actually filed the complaint before the CVA window opened, and then there was a motion.
There was a certified question in Jones as to whether the provision that you're alleging here is a condition precedent or a statute of limitation.
And there are a number of other issues that the Court of Appeals also is considering in respect of that case. So it's not clear that the Court of Appeals will actually address in Jones the question whether the look-back window in CPLR 214G is a condition precedent, as Singer would say,
we will
or a
see.
statute of limitations.
You'll have 2 minutes on rebuttal.
Thank you, Your Honors.
Good afternoon, Your Honors. Arnold DeJoseph for the plaintiff respondent. I won't be so bold as to tell you that Singer is of presidential value to you. However, it's a prior case decided by this court, which it certainly can use as a guideline to render a decision, just as you can look at the Fourth Department cases that hold a different way than Singer did as a guideline to this statute.
Also, keep going, because you aren't actually asking us to follow Fourth Department instead of our
No, I'm not.
So I would move on.
Well, I'm old enough so that this court decided Westbrook, and the Second Department changed its decision. So judges, just like practitioners, are not beyond rethinking how they look at something. But I'm not saying that, Judge. I'm saying this statute has individual language specific to this statute, not Singer, which is the DES revival statute, which is worded entirely differently than this statute. This statute is literally worded just like every other statute of limitations in the CPLR and sets a new statute.
And it starts by saying,
Correct.
I mean, the first sentence of this statute says, let me read it.
I can read it for you, Judge. I got it.
Notwithstanding
Yes, notwithstanding, right? I mean, they specifically refer to the statute of limitations, so there can be no question that that is what the legislature intended to address.
That's correct. Moving on to the pleading part. I think that for the courts and for the practitioners, both the defense bar and the plaintiff's bar, the CVA creates a quagmire of problems in both defending the case, proving the case, and rendering decisions about that. Because the court hit the nail on the head. The plaintiff in this case was 10 years old when this happened. He wasn't in the room when this person was hired. He wasn't in the room finding out how anything was done. All he did was get sexually abused. And the defense here confuses evidence with allegations. There are no witnesses. There don't have to be witnesses in any case. Since when does that matter? Okay? And that includes employment cases, every kind of case. You don't have to have a witness. And
So the plaintiff is a witness.
well, that's, Your Honor, he's
I'm
not
sorry.
talking about the plaintiff. He's talking about independent witnesses. That's at least what I thought the defense counsel meant. But and the same thing holds true with this idea that the 10-year-old plaintiff has to know how this individual was hired and what was said, and the fact that he didn't tell anyone means his case should be dismissed. This is the easy way to get rid of a CVA case before any discovery is done and before anybody can find out anything. And if you look at what's going on, it's practiced all the time. There are tons of cases, and initially, there's a couple of cases that the defense counsel's right. But if you look at the second department cases being decided now, if you look at the case that neither one of us knew, Judge, in this case, which is
It helps you, believe me.
because they got a good, thorough review of everything here, that the reality is that it's not a pleading requirement at this stage of the litigation to make out a prima facie case, which is kind of what he's saying, that it isn't just you can plead, and these are not legal conclusory allegations. These are factual allegations, okay? A legal allegation is the defendant was negligent, okay? Not, the defendant knew or should have known of the propensity of this individual to be abusive. Two separate allegations, and if you look, the allegations throughout all the complaints are identical. If not, I think the court has it. Any questions? I rest on my brief for the rest.
Thank you.
Thank you.
Just a couple of quick points, Your Honors. First of all, the statute in this case, CPLR 214G, is not materially differently worded from the Toxic Tort Revival statute that was at issue in.
Does the statute you're referring to start with the language, notwithstanding any provision of law which imposes a period of limitation to the contrary?
So, Your Honor,
It doesn't start that way.
It doesn't start that way, but the
Okay.
language is in the statute. The language says that notwithstanding the statute of limitations that might otherwise apply to toxic tort claims, those claims are revived provided that they're asserted within the look-back window. This statute does the very same thing, and instead of using the words provided that, says not before and not after. It's actually, to me, hard to imagine that that is materially different language from the language this court considered in Singer. So I think actually that Singer is controlling here. Singer required the plaintiff to commence the claim, not bring a motion for leave to amend, not hope that the statute, that the look-back window was, going to be extended in some way or another, but to commence the claim by filing a complaint and a supplemental summons before the window closed. That's what the rule requires. That's what should have been done here. There was an ample opportunity for the plaintiff to do it. Now, turning back briefly to the pleading issue. The question here is whether the allegations in this case are materially different from the allegations in other cases that this court has rejected for failure to sufficiently plead notice of propensity. And looking at the cases the court has decided, Nagley, looking at Hammond, looking at Easterbrooks, Doe.
And there's a few others that go the other way. So we have cases on both sides of the fence, counsel.
You know, Your Honor, I respectfully, we've addressed the cases that the plaintiff cited in his papers, and we have shown that all of those cases had significant allegations supporting the conclusory allegations of notice of propensity that are completely absent here. So we respectfully request that the court reverse the order below and dismiss this case as against Children's Aid.
Thank you so much.
Thank you, Your Honors.
Star Indemnity and Liability Company versus Monte Carlo. Please wait for my colleague to return, okay?
Your Honor?
Wait for my colleague to return. Okay, you may proceed.
Thank you, Your Honors. May it please the court, Dorchester's good faith claim should be dismissed as duplicative of the contract claim because both claims
Counsel,
arise.
just state your name and who you represent.
My name is Brian Ginsberg. I represent Star.
Thank you.
And Dorchester's claim should be dismissed as duplicative because both claims, the good faith claim and the contract claim, arise from Star's rescission and denial of coverage under the 810 policy.
Yeah, but they add that language about the settlement at Jams or the attempted settlement at Jams and that your client didn't behave reasonably. So that's a different cause of action. No, it's not that doesn't arise from contract. That arises from good faith. You know, in other words, that your Star should at least put some money up toward the settlements, and they allege you could have gotten a good settlement. So
they did allege that. A couple of responses.
Within the policy limits.
Yeah.
I'm sorry, Your Honor?
Within the policy limits.
They allege that in conclusory terms. Now that we're talking about the failure to settle claims, I will go right to that. Dorchester failed to plead non-conclusory facts supporting that part of its good faith claim. Under the Court of Appeals decision in Pavia, the proponent of a wrongful failure to settle claim must show, among other things, that there was a demand for settlement within the policy limits, and that at that time, at the time the demand was made, the litigant had no plausible defense to liability. And there is no non-conclusory allegation anywhere in Dorchester's pleading that, if accepted as true, would satisfy either of those elements. The only things in Dorchester's pleading regarding the fundamental elements under Pavia are just the conclusory recitation of the elements themselves. And that's insufficient under this court's case law interpreting CPLR 3013 and the other standards applicable on a motion to dismiss. You need to plead facts that, if accepted as true, would substantiate the elements, not merely a recitation.
So if we disagree with you and we think that they did plead facts, sufficient facts, plenty of facts, then you lose, right?
Well, we're only talking now about the wrongful failure to settle claim. I have another argument, which was the argument we led with about duplicativity, that the good...
Oh, it's not duplicative. It's not duplicative.
Well, you're...
When the allegation is that you did not engage in good faith to settle a claim for which your insured paid healthy insurance premiums for years, no. It's not the same.
And they were out of pocket because you didn't settle timely. That's the other part of the allegation.
I understand there are distinctions.
They had to pay for attorneys. They had to substitute insurance at a much higher cost. They had to pay for counsel to try some of those cases. So no, it's not the same damages, not by far. So it's not duplicative.
Your Honor, I respectfully disagree under my understanding of this court's case law. First of all, with respect to replacement coverage, I agree that that is sort of a sui generis issue, but they've waived any argument about replacement coverage.
How did they waive it?
They waived it when, in their July 2024 pretrial memo that we cite in our reply brief, they say these are, quote, all 10 components of the damages that Dorchester is alleging. The replacement coverage, which had been pleaded, was not among those all 10 components. So they're not pressing a claim for replacement coverage anymore. But on the issue of damages...
I'm sorry. That you are able to kind of amend and talk about your ongoing damages as the case goes on. So, because sometimes damages develop and expenses develop over time, not at at the inception of the action, right?
That's exactly right. But
Okay.
here that was pleaded at the inception, and now that we're further along in Supreme Court and Dorchester was enumerating its damages in advance of our forthcoming trial in July 2025, they omitted any claim for replacement coverage. So
And
that-
what's the problem with amending the pleadings to the proof at trial as is permitted under the CPLR?
Well,
Seeing as it had already been pled previously?
it had already been pled, but it was then abandoned. I mean, I don't know how else.
Well,
to
that's your argument.
trial memo.
Go ahead.
It is, Your Honor. And further to the issue of damages, I think the damages overlap is one key reason why these claims are duplicative, because each item of damages requested in connection with the good faith claim, which is enumerated at 132 to 133 of the record, the damages itemization, is just a specific part of a general item of damages requested on the contract claim. For example, in connection with the good faith claim, and this goes to what Your Honor's colleagues were discussing as well, they request indemnification for a $1.5 million settlement in one of the underlying cases. That's just a specific part of the general category of damages prayed for on the contract claim, where they seek indemnity for all claims in that same case, and they do that for all three of the fire cases. Now, it is true, as Your Honor said, that on the good faith claim, there is no damage cap. So the amount of damages within any given category that they could legitimately pursue would be higher than it would be in connection with the contract claim. But that is a matter of degree, not a matter of kind. If I could finish my thought before I sit down.
You have 30 seconds.
And that matter of degree does not make the damages, quote, categories and or types of damages that are different, which is the language that my friends on the other side rely upon from the East Ramapo decision.
All right, you'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. Franklin McRoberts, Farrell Fritz, PC, for the respondents. Did the court have an opportunity to read the case that I sent last week?
Counsel, you don't get to ask the court questions.
It's a
Make your
decision-
argument.
It's a decision from exactly...
Make your argument.
I am. It's a decision from exactly 3 weeks ago from this court. It's called Rockefeller University versus Aetna, and in that decision, this court did exactly what I'm asking the court to do today, which is affirm the denial of dismissal under 3211 of an insured's claim of bad faith as duplicative of a claim of breach of contract. In that case, the court, relied on a long line of authorities from this court before it, including the New York Botanical Garden case, holding that where an insured alleges different conduct and different damages in the bad faith claim than it alleges in the breach of contract claim, the claim isn't duplicative. And my adversary...
It's okay to have some overlap of the facts.
Exactly.
The same claims. That's what Botanical Garden stands for.
That's exactly...
But what do you got about the non-fire cases?
Yeah.
Like the two slip and falls. How do you have a good faith claim there? Breach of good faith claim there?
Well, we
Montefosco
alleged...
and what's the other one? I forget the name of the other one.
Nunez.
Nunez. Thank you.
Those claims, the damages don't exceed the policy limits, so they don't really fall within the bad faith claim, I'll be honest with you. The damages for bad faith really are limited to the replacement premiums that we talked about before, and what my adversary said is absolutely wrong. It's based on subsequent events to horse the record. He can't rely on that. We pled those damages in our pleading. The court held that that was not duplicative. It was a separate component of damage. I mean, he's an appellate practitioner. He knows you can't rely on things subsequent to the record before the motion court. But the Frias, Ramirez, and Burles claims, they totaled $3,650,000. There's a $2 million limit per location in the policy. So you've got $2 million within the limits and $1,650,000 over the limits.
I thought it was $1 million per incident and $2 million total, but I may be mistaken.
There's an endorsement in the policy, and it's not in the record. It's called a general aggregate. Sorry, I'm getting it wrong. Designated location general aggregate limit, which says the $2 million aggregate, it applies per location. And there are 11 locations under this policy. So to go back to your question, the Nunez and Montefusco cases, those are at separate locations. They're within the limits, so they really don't fall within the bad faith claim. But you do have separate components of damage for the fire cases that exceed the policy limits. And in the Rockefeller University case from 3 weeks ago, the court said where you've got a contract claim that caps damages at the policy limits, and a claim for extra contractual damages over the policy limits, the claims aren't duplicative, and that's exactly what I'm arguing here. As far as the...
So I guess on Montefusco, you didn't get any representation either, right?
Right.
No, I defended that case, and I did the trial because the insurance company refused to defend it. And they relied solely on the rescission to do it, and they've lost on rescission. This court dismissed the insurance company's complaint. They tried to replead their coverage defenses, and I argued in front of you 6 months ago. The court dismissed those defenses again. Yeah. And I'll just say, this is the third appeal we're doing in this
Yes,
case.
we all hope that you have a trial date before July.
Well, what I'm saying is, this is the third appeal. My opponent has told us there's going to be a fourth. There's been 34 motions before the motion court. We're going to do a trial. What Starr doesn't seem to understand is that it is an insurance company that sued its insured and it lost. Under Mighty Midgets, they have to pay my client's legal fees. And I don't want to hear my opponent stand up in front of this court 2, 3, or 4 years from now and complain about a huge legal bill. If the insurance company has to do it, it's its own fault. Thank you.
You have 1 minute.
Just a couple points in rebuttal, Your Honor. At pages
1 minute.
Yes, Your Honor.
Okay.
Pages 34 to 37 of my friend's brief, Dorchester enumerates what they call the most important facts above and beyond the contract breach that form the basis of their good faith claim. Those additional facts, to be sure, make Starr's rescission and denial of coverage allegedly more blameworthy, more culpable, and more ill-motivated, but they are not alleged to have caused Dorchester any more harm above and beyond the harm flowing directly from the rescission and denial itself. And for that reason, among the other reasons we've discussed here today and in the briefing, the good faith claim cannot plausibly be said to arise from those additional facts. The second and last point I'll make is on the damage cap issue. That is not what Rockefeller says, or at least it would be an overreading of Rockefeller, because by definition, a good faith claim never has that damage cap, and a contract claim always does. So if my friend's reading of the Rockefeller decision were correct, then good faith claims would never be duplicative of contract claims. We know that from this court's case law that they are, and we respectfully submit that this one is as well. So we would ask the court to reverse. Thank you, Your Honors.
People versus Terrence Graham. You may proceed.
Good afternoon, Your Honors. May it please the Court, Avery Leshin, appearing under the Student Practice Order on behalf of Mr. Terrence Graham. Your Honors, we are asking this Court to exercise its independent discretion to reduce Mr. Graham's sentence in the interest of justice. While Mr. Graham was originally sentenced to 8 years in prison with 5 years post-release supervision, he was recently released early for good behavior earlier this month. And thus we are asking the same from the court to reduce to 7 years prison and 5 years post-release supervision, but the practical implication would be a 1 year reduction in his post-release supervision.
1 year reduction in PRS, is that what you said?
Yes, the reduction of PRS to 4 years.
So from 3,
Well, we're still asking from 5.
got it.
Yeah.
Wait, you can't reduce the PRS to 4 years. You're asking us to reduce the incarceratory sentence.
Yes, exactly, Your Honor. I apologize. Yeah. The practical implication would just be a shortening of the PRS. There is no penological purpose. I apologize. The purposes of incarceration were duly served by the 7 years that Mr. Graham has already served. While incarcerated, he worked incredibly hard to improve his vocational skills, his education, and his support system. He has developed very strong relationships with Miss Alexander, who has promised to support him financially and emotionally upon his release, as well as Miss Shafi, his therapist, who will continue to see him upon his release, as well as his sons, who he sends poetry and letters to, even finding ways to consent to their surgery.
Counsel, was all this information before the sentencing court?
Yes, Your Honor. However, that court was focused on the unconstitutionality of Mr. Graham's original sentence and didn't fully take into account the weight of Mr. Graham's circumstances, both as a child and adolescent, as well as the incredible things that he's done while in prison.
This was his fifth felony conviction, correct?
I believe, Your Honor, there's been a lot of changing things for prior. However, his convictions that occurred while he was at liberty all occurred from the ages of 16 to 19, while Mr. Graham was in an extremely tumultuous period of his life. Mr. Graham had experienced 7 out of the 10 core adverse childhood experiences, or ACEs, by the time he turned 10. No one was watching to make sure he went to school. No one was teaching him job skills, life skills.
A lot of children all across the nation survive childhood trauma like you have just described and do not go on to become recidivist felony people who engage in felonious activity. And so while I am grateful that he has utilized his time in prison to help himself so that he can come out and be on the right track and be the father that I think he wants to be, right? You're asking us to change PRS time, basically. The effect, as you said, the effect would be to reduce his PRS time in someone who demonstrated that over a petty little squabble at work, he lost his mind, left the job site, went and came back with a 9mm gun.
3 hours
to be
later.
tackled by his coworkers to prevent him from shooting a coworker. So I don't know that reducing his PRS time is a good thing. Maybe he needs that supervision to keep him on the tight and narrow. Why am I wrong about that?
Your Honor, this post-release supervision will be onerous on Mr. Graham and potentially even harm his rehabilitation because it restricts his relationship with his sons. They will likely impose a curfew, meaning that after a long day of work, he cannot go to tuck his sons into bed. He can't attend their evening sports games or band practices. If they were to move out of state...
That's going to be the case anyway, right? So even if we were to reduce this, all it does is change what you have just described somewhere down the line, 3 years from now. It doesn't immediately impact. So he will still be subject to all of the restrictions you are describing because anything we do is not going to impact him immediately. He will still be subject to PRS, and he will still be subject to whatever imposition of time restraints and curfews, et cetera. So I don't see how us changing this changes the dynamic for him immediately anyway.
Your Honor, that will be a year back with his sons to be able to visit them, to be able to fully live out this relationship, this friendship with Miss Alexander, to visit his sons. If they were to move out of state, he may be restricted from seeing them all together. A year is a very long time, and his sons have already been separated due to Mr. Graham's actions from him for 7 years. That is retribution enough. Mr. Graham just wants to be reunited fully with his sons as soon as possible. Thank you.
Good afternoon, Your Honors. May it please the court, Jennifer Mitchell for the people. Defendant's sentence was appropriate and should not be disturbed on appeal. As a second felony offender, defendant was facing a maximum sentence of 15 years in prison, yet he received a sentence of only 1 year above the minimum in this case. All of his purported mitigating factors were already fully considered by the resentencing court below and do not warrant a reduction in this case. And in fact, But
we can look to his behavior and his conduct while in prison as a measure for what we can anticipate from him now that he is released. So why should we not consider the request of counsel insofar as the request shaves off a year, which really amounts to about 8 months of time once corrections does their calculations. So why is that so egregious a request?
Your Honor, it's our position that, it's great that defendant received benefits and he's improving through these programs that he participated in prison. However, this was an extremely serious case. And he threatened his coworker, as you stated, with a 9mm pistol. He would have followed through on that threat. Defendant had time to go home, cool off, and calm down, and instead chose to retrieve a gun and return to the workplace and follow through on his threat to kill his coworker, and was only stopped because other people interfered. This is also, as this court has already mentioned, his 5th felony conviction, 4th violent felony conviction overall, and based on these aggravating factors, it's our position that the sentence as it stands is appropriate in this case, and there's no reason for the court to reduce. If there are no further questions, then we ask that you affirm.
Thank you.
Thank you.
Your Honors, there were extraordinary circumstances in play behind the instant conviction from December of 2017. Mr. Graham's youngest child, Kaysen, was in the hospital undergoing heart surgery at some point, severe complications. He was stuck in the NICU for months. Mr. Graham was working overtime 6 days a week, spending his days off visiting Kaysen in the hospital, then going to see his older child, Karan, in the same home where Mr. Graham grew up and was neglected. He was skipping meals in order to provide for his sons. And so under all of that, he had a workplace conflict and made a bad decision. And Mr. Graham admits that. He wrote in a 2023 letter to the court that he knows he should have stayed home. He did not manage his emotions appropriately. And during the past 7 years, he has worked extremely hard to remedy that. He has taken courses through the NCCER, the National Center for Construction Education and Research, on managing conflict in the workplace, dealing with stress, getting along with your coworkers, and building a strong relationship with your supervisors. He has worked on self-control with his therapist, Ms. Shafi, extensively. And so we ask your honors to reduce his sentence in recognition and in support of his continued rehabilitation. Thank you.
Counsel, I want to say, we from time to time hear students argue under the practice order. And I want to say bravo to you.
Thank you.
You were excellent.
Thank you.
No matter what happens, no matter which way we decide, okay? You were excellent, and I'm sure that your adversary joins me in that. You will do very well in this profession, and you should go home tonight feeling proud of yourself.
Thank you, Your Honor. I appreciate that.
You're welcome. Thank you. HMC Assets versus Simmer. He's got 2 minutes, don't worry.
Good afternoon, Your Honors. May it please the court, Ronald P. Lebeck for the plaintiff respondent. Initially, Your Honors, and really my primary reason for orally arguing, because appellant's not here, is to withdraw my initial argument regarding matter of AHO. It's based on a misreading of appellant's brief and his filings in this and under the judgment, with apologies to the court. Nevertheless, the summary judgment motion was properly granted. I would rely on my brief with that, particularly with regard to the inapplicability of RPAPL 1304. Clearly, appellant Lee is not a borrower as construed by the statute, nor is she entitled to a notice pursuant to the mortgage. Appellant Simmer, having transferred his interest in the property, he's not a tenant by the entirety. He did transfer his interest, although he is married to the appellant Lee. That does not mean he has an ownership interest in the property. That would preclude the applicability of 1304 to him also of RPAPL. To the extent he's allowed to assert any defenses with regard to the property having divested himself of an interest, I think respondent has amply demonstrated its service of the default notices, both under RPAPL and the mortgage, through admissible business records and through testimony as to the practice and procedures for mailing such notices. Thank you, Your Honors.
Thank you so much. Schmidt versus Board of Directors.
May it please the court, my name is Ethan Cohen from Rosenberg and Estes for the appellant. We respectfully request that the court reverse the order from Supreme Court which dismissed this entire action on a pre-answer motion to dismiss. We think this case symbolizes the entire purpose of the protections in the Business Corporations Law 616A and B2 and 803A, which protect shareholders and do not permit a board to usurp or eliminate a shareholder supermajority provision as long as the certificate of incorporation provides notice that there are certain actions of the shareholders that require more than the majority vote. Here,
Yeah, but does the certificate of incorporation here do that? Or it rather delegates to the bylaws?
yes, Your Honor, I think that is a point that looks to form over substance. Here, the certificate of incorporation does specifically provide that pursuant to the bylaws, it notices the bylaws and says there are certain provisions that require more than the majority vote, and those provisions in the bylaws require a unanimous vote of the shareholders, which gave them an absolute veto for certain items that the board here took a vote of the shareholders. The shareholders rejected the transaction, and then the board simply used their simple majority, which was 2 shareholders out of the 8, to entirely eliminate the supermajority provision, reduce the shareholder voting to 51% for one of the items, and entirely eliminate the vote of the shareholders for one of the other.
No, we understand all that, but isn't the problem here a process problem, rather, like how the meeting was called concerning the amendment of the bylaws? In other words, there wasn't enough sufficient notice to all the shareholders about what was being considered.
Yes, Your Honor. In the shareholders' notice, there was also there wasn't any. They didn't provide the actual lease that was going to be considered at the meeting. The board here.
And that was required.
Yes, Your Honor, that was required. And also, I'd like to point out that they, like I said, they did take this vote, and the board here on their motion to dismiss did not prove that they complied with even the provisions of the bylaws, even if those were enforceable, that would have allowed them to act by majority vote to usurp and trample on this supermajority provision. They relied exclusively, almost exclusively, on a factual affidavit, which is improper as a matter of law on a pre-answer motion to dismiss. They alleged that they held a board meeting. They alleged that they received proxies from the shareholders. They alleged that these were the original bylaws. They didn't put any documentary evidence of these items. And in addition to that, they did not even allege the requirements of the bylaws that they had inserted this in the notice of the board meeting, or that they had all the members present. So they did not meet their burden on this motion.
Was there a copy of the notice attached to the record?
No, Your Honor. So for several reasons, both procedural, that they relied on a factual affidavit, and I think this case provides a unique opportunity for this court to protect the rights of shareholders that the legislature clearly codified in 616 and 803, even if it is this distinction between whether it says pursuant to the bylaws or not. I think it's important that here the certificate did provide the requisite notice, and just because the unanimous provision is in the bylaws, the certificate gave notice of that, and that should be provided with the same protection for any supermajority provision. Any further questions? Thank you, Your Honor.
May it please the court. My name is Michael Savino from Braverman Greenspun. We represent the respondents. In terms of this action, there are a number of different governing documents to which the co-op forms and to which the co-op operates.
Where do I have a copy of the notice that complies with the mandate that is required of the board of directors in noticing this board meeting and the items to be decided at the board meeting?
Your Honor, in terms of the notice...
I don't have a copy, right?
No, Your Honor, you have the meeting minutes and record.
No. I said the notice, because the notice requires you to advise the people in the building what's being voted on. Where is that in the record?
Your Honor, there is no lease in that record. There is
no notice? I keep on asking about a notice, and you keep on talking about something.
I'm sorry, Your Honor. There was a notice that was sent out regarding the special meeting.
And where is that in the record?
That is... Apologies, Your Honor. I did not have that queued up.
I don't think you're going to find it.
I couldn't find it. That's why I'm asking you for it. Because maybe I missed it.
There was a letter that went out to the shareholders regarding the...
See, part of the problem you have is that as a board, you must follow your own bylaws. And your bylaws say that you have to send out a notice to the other shareholders saying exactly what is going to be voted on. So unless I have that in the record, you can't win the day.
Well, Your Honor, in terms of
Period, Full stop. Without that in the record, I don't have a factual basis upon which you can prevail.
Your Honor, if I may make the distinction in terms of a notice. So there was a notice to the shareholders regarding the roof lease attaching the amended bylaws. The provision which allows the board to amend the bylaws by director action was included in the original bylaws, to which 2/3 of the board can move to amend the bylaws.
That's not what your bylaws say. Your bylaws say when you are going to take a vote, you must provide a notice to your shareholders. That notice must include specific detail about what is going to be voted on. That's what your own bylaws say.
Your Honor, with regard to the amendment provision, which was Article 12 of the original bylaws, said these bylaws may be amended, enlarged, or diminished either A, at a shareholders meeting with shareholders owning 75% of the amount of the original, and then it goes on.
And what proof do I have that that was done here?
None, Your Honor, because there's no requirement for that, because
Okay.
the next sentence, or at a meeting of the board of directors by a majority vote, provided
And how
that
do I know how many board directors there are and who was present at the meeting? How many are there? Is there a document anywhere in this record that tells me the board of this condominium has X number of board members, here are their names, and this is the meeting, and this is who was there? Do I have that?
On page 378 of the record, Your Honor, those are the meetings minutes from the board, and it says a meeting was called. Present were Tony Dove, Greg Rossi, Megan Cook, and Seth Weinstein, managing agent. There was a discussion about the bylaws for Dwayne owners, in which the amended bylaws.
Counsel, I could read,
Does
but
that-
that didn't tell me whether, how many board directors there are to this board. You tell me who's there, but I don't know who's not there. Maybe everybody's there. I don't know. So tell me where in the record you establish who the board is so that I can then juxtapose that against your minutes to see if you have complied.
Your Honor, in terms of the information you're looking for, I do not have a document within the record which states exactly who is in the board, other than within the bylaws, which sets forth the actual positions within the board. I will posit that the directors that were listed within the notice on 378 comprise the entire board, and the majority, by a majority I mean every director, voted in favor of the amended bylaws. So pursuant to the original bylaws, Article 12, the bylaws were properly amended by action of the directors, which rids the obligation to notify the shareholders of any amendment to the bylaws because they carried out this director action. And one of the other requirements for director action to take place was the fact that no bylaw was amended by shareholders prior to the director action. And we've included the certificate of incorporation, whereby the building was converted into a condominium with the residential unit comprising the co-op. And the original bylaws from the conversion are attached to that, which comply with the bylaws in which were amended.
Okay, we'll take a look.
Thank you.
Counsel.
Thank you, Your Honor. As the court duly noted here, everything that counsel has relied upon on their motion to dismiss was only stated in an affidavit. There's no documentary evidence supporting this. Several of the documents cited by counsel here were only submitted on reply, and here they relied only on a factual affidavit to even say that they had a meeting. They used an ellipses to eliminate the provision that required them to provide notice of that meeting or have all the board members present. They didn't even allege that those were met in their affidavit, which would not have been sufficient anyway. In addition, I would ask this court to say that even if they had met those provisions, they still have a hurdle to get over under 616A and 803, which requires a 75% vote of the shareholders to overcome a supermajority provision. Here, the order should be reversed and the action reinstated for this to be litigated in Supreme Court.
Thank you so much.
Thank you, Your Honor.
Fishman versus Isalis. They're all gelling together.
Good afternoon, Your Honors.
Good afternoon.
For the appellant, Michael Joseph from the law office of Michael H. Joseph, PLC. Your Honors, it's our position that the court below erred in finding that the defendant's experts were sufficient to rebut plaintiff's prima facie showing of entitlement to summary judgment on the issue of serious injury because the experts' opinions were conclusory, they were speculative, and they were cleverly tailored to avoid summary judgment. I think it's been, at this point, black letter law that experts' opinions require a foundation of evidence in which to provide a opinion. The defendant's experts in this case did not review any of plaintiff's records from any of his treatment for occipital neuralgia, including 4 different surgical procedures. They likewise, Dr. Fairman never reviewed any actual MRIs, and in fact, in his letter, asked to be provided with MRIs, and the MRI in and of itself does not show this particular injury because it's a nerve that articulates between the top of the cervical spine and the base of the head. With the defendant's inability to provide a opinion that either the occipital neuralgia is not related to the accident, plaintiff established an unrefuted prima facie case.
I think the fact that your client has had multiple injuries affecting similar parts of the body, some of which may have had some impact on this diagnosis, creates an issue of fact as to which accident was the precipitating cause of his condition.
I would agree with you, Your Honor, if we did not also submit the report of Dr. Costello, who examined plaintiff as part of an independent medical examination 6 months prior to this accident and well after any prior accidents, and Dr. Costello found plaintiff did not have any complaints of the neck, no restrictions in motion, no spasm, and had no disability or injury to the neck of any kind, and any injury he had.
He had multiple accidents where he said he had neck and back injury. All
of which had recovered at a point in time 6 months prior to the instant car accident, and plaintiff had never been diagnosed with occipital neuralgia prior to this accident. There was no, and in fact, I think the court below found plaintiff made a prima facie case of serious injury based on the combined affirmations of Drs. Brotea, Dr. Dalal, and Dr. Costello, as well as Dr. Lerner.
Okay, we have 2 accidents here, right?
Correct.
The first of which was, and I'm being gratuitous, was a tap. It was like that's all it was. The expert report about the repair to the car said there is no damage to the plaintiff's car at all.
1, Your Honor, that report is not sworn, it's inadmissible, and 2, occurred after the vehicle had actually already been repaired. So that is insufficient to establish.
We also have the independent witness who's standing right outside of the school pickup. This is not a fast-moving lane. This is cars moving an inch a bit while children get out of their parents' cars and then the next car pulls up. That is the first accident.
Except what the car did was it sped up to cut around, and this is a large truck. And this witness, Ms. Tam, did not even see this accident because why? She says that the accident she observed occurred in the afternoon, a block and a half away, and described the mechanism of the accident completely differently. That testimony has no foundation or cannot be relied upon as probative when even the defendant said the accident occurred in the morning and described a completely different accident and a completely different location. Ms. Tam's testimony is either incredible as a matter of law or she's describing another accident that she observed, not this accident.
Okay.
If I could take a step back, Judge, to the doctor's opinions, where the doctor, first of all, Dr. Fishman was not a neurologist. He's opining outside of his opinion without any basis. Dr. Anand is entirely equivocal, saying he criticizes the diagnosis as speculative, having been done speculatively based on plaintiff's own treating doctors, but he's never reviewed any of the records. So it's entirely conclusory and equivocal for a doctor to say the diagnosis is speculative when you don't review any records as to how that particular doctor came to that diagnosis. And in fact, they can't even, I don't think they can even base in this case, the opinion on an exam because they examined plaintiff while his neurostimulator was artificially controlling any symptoms he would have, or the mechanism that the condition causes. You can't say he has no disability or symptoms or findings from a condition when that condition is being artificially controlled. It makes it conclusive, Your Honor. Conclusory. Thank you.
Good afternoon, Your Honors, and may it please the Court. Sean Kelly, Traveler, Minstrauss, and Shrewsbury LLP on behalf of the defendant respondents. Simply put, the lower court's decision denying plaintiff's motion for summary judgment should be affirmed for two principal reasons. First, the defendant's experts' opinions sufficiently rebut the plaintiff's prima facie showing of the alleged occipital neuralgia that being causally related to the June 10th accident. And then secondly, the record is replete with additional evidence, particularly testimony evidence, that create issue of facts as to whether the June 10th accident could have caused the alleged injury of occipital neuralgia. Now, I would like to start first with the testimony evidence relating to Mandy Tim, the non-party witness. As my colleague on the other side had testified that Ms. Tim had testified that the accident occurred a block and a half away. This is incorrect. Ms. Tim did originally testify to that, but then upon presented with an opportunity to refresh her recollection, she corrected her testimony to explain that the accident happened the morning of June 10th at the school, and she described it, as Your Honor noted, as a mere tapping of the vehicles. She further testified that she did not observe the plaintiff's vehicle move after the impact. She didn't hear any sound from the impact, and then upon personally inspecting the plaintiff's vehicle, she did not see any signs of damage. In addition to Ms. Tim's testimony, my client also testified that the accident happened at low impact, approximately less than 5 miles per hour, in which she characterized it as a mere rubbing of one bumper against another. Now, with respect to my first point with the defendant's experts, it's important to note that the experts did review medical records, relating to the prior accidents that the plaintiff had, which I believe is approximately 4 of them, and then also medical records from after the June 10th accident. Now, I know my friend on the other side has made a point of saying that the doctors did not relate their findings to the first 180 days after the accident. However, this is incorrect. The record shows that there were, for Dr. Fairman, for instance, he related his findings to the first 180 days by reviewing the MRI reports of the brain, which occurred from July of 2013, an EMG of the upper extremities from September of 2013, an MRI report of the cervical spine from October of 2013, as well as CT scans of the head and the neck from November of 2013. Now, Dr. Fairman goes on to explain in his report that the basis for his opinion is that the etiology of occipital neuralgia is cervical spine pathology, which is present in multiple of the prior accidents that the plaintiff had happened. Additionally, Dr. Fairman explained after personally examining the plaintiff, his cervical spine, he found that he had full range of motion and that he did not find any new signs of pathology for the cervical spine. With respect to Dr. Anat, who is the neurosurgeon, he also reviewed medical records relating to the prior 4 accidents that the plaintiff was involved with. And with respect to the first 180 days, he also reviewed radiology films, including an MRI scan of the cervical spine from October of 2013, also an MRI scan of the brain from July of 2013, as well as CT scans of the brain, head, and cervical spine from November of 2013. And now, Dr. Anat also explained in his report that his review of the plaintiff's prior CT scans and MRIs of the brain revealed no abnormal pathology. And that is where he came to his conclusion that the plaintiff is exaggerating his subjective symptoms and that there is no objective documentation of an injury that would support injury to the brain, skull, or cervical spine, which would support a conclusion of occipital neuralgia. Unless there's any questions that the court has, I will rest on my brief.
Thank you. You have a minute, counsel.
Occipital neuralgia is not part of the skull, it's not part of the cervical spine, and it's not, the occipital nerve is not part of the skull or the cervical spine. You can't see it on an MRI, even had these doctors reviewed the MRIs, which they didn't, and in fact note in the reports that we'd like to review them. Neither of these doctors who examined plaintiff 6 years after the accident, neither of them made any reference to his condition during the first 180 days, nor could they, because they never reviewed any of the records of his treatment for the first 180 days. They didn't review any of the records of the doctors who actually diagnosed occipital neuralgia, nor did he do any tests which would actually document or diagnose occipital neuralgia, such as compressing the occipital nerve, like Dr. Dalal did, nor did they even review the diagnostic nerve block, which Dr. Anat says, I don't see records of a diagnostic nerve block, I'd like to see it, and he doesn't see it. So how can they possibly, in a non-conclusory manner, say what his condition was, what his injuries are, where they see nothing and look at every medical record under the sun other than occipital neuralgia records.
Thank you.
Thank you.
Travalia versus 135 West 52nd Street. You may proceed.
May it please the court, good afternoon. Nicholas Napoli on behalf of the defendant appellants. This action arose out of a tragic incident. The plaintiff's decedent, Bruno Travalia, fell from a 47th floor roof. The appeal that we're taking before Your Honor today is from the Supreme Court's decision and order that denied my client, 135 owner, New Line, which are respectively the owner and construction manager for this project, denied the motion for summary judgment under 240 and section 241.6 of the labor law on the basis that the plaintiff's decedent was a recalcitrant worker, and we were also
What proof is there anywhere in the record that he was a recalcitrant worker? I saw none.
Sure. So the trial court's decision relied upon this court's precedent in.
I asked the question, so tell me.
Sure. So there
What order was he given by anyone that he ignored?
Sure. So there was testimony from the New Line's witness that there was certainly explicit instruction for all trades on this project to be having to be both wearing a harness with a lifeline
And he was wearing a harness. Correct. The problem was, in order to actually utilize a harness, you have to have a place where you can tie off.
Understood.
And there were plenty of witnesses that should have been favorable to you, that said there were none. And photographs of the site shown to your witnesses, not one of them could say, there it is. Not one. So on the corner where he fell, because I don't want to hear about the other side of the building where workers did have a tie-off line and were able to safeguard themselves, because he was on the opposite side. Right?
Yes, Your Honor.
And there was no tie-off. There was no place for him to tie off. So he was doing the right thing and had a harness, but had nowhere to tie off. So tell me, what safety device did your clients provide to prevent this man from falling off that roof to his death?
Yes. So there was testimony from New Line's witness, Jason Prasad, who was an assistant project manager, and he described what was a wedge anchor system. There would be a wedge anchor that was drilled into the surface of.
But there was none. So we could talk about what should have been, but show me where in the record Prasad says, there it is. Look, I went up after the accident. It was right there. That's not in the record.
Well, the testimony was, and this was, there was a uniformity between Mr. Massaro, who was a former Crown employee who was there at the time of the accident, and Mr. Prasad. And as my recollection is that the testimony on this particular point between those two witnesses is the same, which is that there were wedge anchors available, but given the proximity of the work, that the workers would have to sink those anchors in. And Mr. Massaro, in all of his testimony, he didn't testify that that system was inadequate. What he testified to was that they had been told, and he even acknowledged that there was constant reiteration that the trades had to be able to drill into the roof to sink the anchor.
So wait, you don't provide safety, you tell the workers to create their own safety. Is that your argument?
Well, my argument, I do believe that
I think that's what I just heard you say, that the workers were told, go screw in whatever latch, whatever it was you called it, screw that into the roof so that you don't kill yourself. Is that basically what we have here?
The record was that the wedge anchors were provided, and I believe the testimony was that.
Counsel, how does that comport with the labor law? The labor law says that an owner and a general contractor has to provide a safe place for its workers, right? We can
Correct.
agree on that.
Correct.
All right. And clearly, The photograph I saw of this teeny weeny little wall, 18 inches high, isn't gonna protect anybody, not even an infant, who could roll over that thing and fall off the roof, right?
Certainly, Judge.
Okay,
We're not.
so then we are looking for, what did you provide? Not, here, use this and make yourself safe. What is on the roof that I as a worker can tie into so that I don't kill myself?
All of the system is the harness, the lifeline, the anchor, and the anchor has to be put into the roof by the worker. And what I was going to respond is that there was testimony that the reason for that the worker would sink the anchor themselves is based on the proximity of the work. They're moving around, and this system is reliant upon that. And to that effect, Mr. Massaro did not.
Where in the labor law does it permit a building owner and a general contractor to exercise construction in this way? Where?
Well, to that I would respond that Mr. Massaro's testimony was that, and this is not a point that plaintiff's expert hinged on. They weren't disputing the sufficiency of the system. They were disputing their ability to enact it because of the testimony from Mr. Massaro. He didn't say that there weren't wedge anchors for me to use, or that if I had used them, it wouldn't work. He said
there was nothing to tie off on.
He said, Your Honor, respectfully, what he said was that we were unable to put the anchors into the surface of the roof because the Kemper waterproofing had been put down, and the new line told us that we were not allowed to penetrate that waterproofing membrane.
Are you saying that it's permissible to transfer your responsibility to keep this work site safe by making the construction worker responsible for putting in the wedge?
I wouldn't characterize it, Your Honor.
That's exactly what you're saying. That's exactly what you are saying. That you have dispensed with your obligation under the labor law by saying, here, put this on the roof so that you don't die. That is exactly what you are saying.
I don't believe it is, Judge. And respectfully, the argument...
So you say in this circumstance where I think you agree that the wall is insufficient, that you as the owner, general contractor, whatever your position is, telling the construction worker, here's the wedge, that you've satisfied your obligation under labor law.
Well, there was also instruction in terms of how to apply it, where to apply it.
Well, we know that instructions under our precedent is not a safety device.
I was
right?
not
So that's
conflating
not
those
enough.
issues, certainly. And to each of Your Honor's point, we are not, the argument is not that the system, that the wall was part of the system. In fact, it's the polar opposite of that. It's the system is designed in this way to account for the layout of this particular work area.
For the lack of a safety wall around
to
the edge
protect
of the
against,
building.
right, it's a leading wall. And there was testimony from actually one of the witnesses from Safety Squad who was no longer in the case, post depositions, and he testified to that effect. And he was not an expert witness, but he said when you have a leading wall like this, that, you know, where the wall itself is not going to be sufficient protection from an elevation-related risk, there are a number of different, fall protection systems that can be employed. And there was not testimony from him that this system was inadequate. It was, and Mr. Massaro didn't say it was inadequate. He said we weren't able to use it. And our argument ultimately is that that's where there is at minimum an issue of fact, because Mr. Prasad said that is absolutely incorrect. The parties on every project I've worked on this project prior to the day of the accident, consistently would drill through the Kemper membrane.
I suggest they rethink that method. You'll have time on rebuttal. Thank you.
Good afternoon, Your Honors. Stephen Dorfman from the Parisman firm on behalf of plaintiff respondent. I'm at somewhat of a loss of words here because Judge Manzanet and Judge Rodriguez really filled in all of the blanks that I was hoping to discuss. But
Counsel,
I would like
what
to
about the photo that's at record 2404? That was the photo that was taken about a week before the accident that has documentation on it. It's written that these are tie-off points. What should we make of that? That they were too far away from the place where the
I would start, Judge Moulton, forgive me, I didn't mean to cut you off, with the simple fact that appellants never produced that photo during the course of discovery. They never identified those photos. They never produced anyone to authenticate those photos as being fair and accurate depictions of the roof at the time of the accident.
Were they during EBTs brought up?
No, Your Honor, they were not. It wasn't until they were opposing our motion for summary judgment that suddenly those photos miraculously appeared. And that brings up a very important point to the court. This is a 50-story building, an enormous project, multiple trades, over 100 tradesmen per day on this project. There's a fatality. We all know, of course, this court has faced hundreds, if not thousands, of construction accident cases. In circumstances like this, there would be an investigation, an incredibly thorough investigation. And if there were wedge anchors or other safety devices there that appellant's company was aware of, we would have seen that. There was no such proof here. The only proof, the clear proof here is, according to Mr. Massaro, the only eyewitness, there were no rope grabs, no lifelines, no anchor points, no guardrails, and no netting. Mr. Travalia went up to the roof that day with a harness, with the full intention to tie off. Their own superintendent went up there without a harness. Why? Because he knew there were no safety devices there to tie off on. He wasn't there for a fleeting moment. He was there for 10 minutes to discuss the work being done. He did not tie off because there were no objects there for him to tie off.
God, he was in the middle of a conversation with the man, turns around, and the man is falling off the roof.
That's correct, Judge Manzanet. And he never instructed Mr. Travalia to tie off, again, because there were no places to tie off. They cannot satisfy their burden for a recalcitrant worker. They cannot satisfy their burden for raising a question of fact. This is on point with Miglianico, where this court set the standard on how an appellate, or rather a defendant, should oppose a motion for summary judgment. You can't simply say, yeah, I think there was stuff there, but I don't remember, I don't know what it looked like, I don't know if it was there on the date of the accident. That's what they're trying to do here. And I ask, unless the court has any other questions, that they affirm Judge Sattler's decision.
Just while you're there, Mr. Chetrit, he's not a proper labor law defendant, is he?
No, and we didn't move against them.
Right. Okay, you did note that in your papers. Thank you.
Thank you.
Thank you.
You may proceed.
Good afternoon, Your Honors. May it please the court. Adenine Medina for the respondent, Crown Architectural. We're here to ask the court to affirm the portion of the order that denied the appellant's motion seeking summary judgment motion as to the third-party claims against Crown. At the time that the motion was interposed, the original underlying summary judgment motion by the plaintiff, Crown had not even appeared in the case. Crown appeared a week later. By the time Crown appeared and realized that there was a motion for summary judgment pending, note of issue had been filed, we immediately moved to vacate the note of issue to allow us to proceed with discovery.
Your discovery.
A lot of sort of procedural things happen in the interim between us appearing in the case and the case being decided, the motion being decided, including motion practice to obtain discovery. And in fact, on the date that the oral argument on these motions took place, that's the date that our firm actually received discovery. And it had been over a month since we had had to essentially compelled to submit opposition, advising the court or reminding the court, who was fully aware of the procedural status of the case with respect to third-party action. And that's the reason that the trial court, fully aware of the procedural position of Crown in this case, decided to deny the motion with leave to renew. And Crown never availed themselves, I'm sorry, the appellant did not avail themselves of a motion for leave to renew. Instead, they proceeded with the appeal. Discovery was actually completed only a few weeks ago. A motion for summary judgment has been interposed on behalf of Crown. And I submit that the correct procedural avenue for the appellant should have been a motion to renew. This appeal is actually premature. The appellant should have availed themselves of a motion to renew after the completion of discovery, which happened a few weeks ago, and that motion, our motion is currently pending for summary judgment before the trial court. And
based on the contractual language, not a common law indemnification, but based on the contractual language, is there a reason why this court should not grant a conditional grant of the indemnification just based on the contractual language, awaiting to see what the trial determines with respect to liability?
At this point, it's premature, Your Honor.
Why?
The evidence indicates that the appellant may be at fault or was at fault according to the order of the trial court, and therefore they are precluded necessarily from getting indemnification from Crown by virtue of the fact that they may be liable. They may have been...
Right, but that's why I say conditional, so that if they are found liable, then the court can deny the conditional grant,
But
right?
at this point, the order on appeal has found them liable. So by virtue of that, there can't be any conditional finding of indemnification at this point.
Okay.
Thank you, Your Honor.
All right, you have time on rebuttal. You have 2 minutes, all
I'll
right?
try to be as succinct as possible. And just because it's fresh and I didn't get to it initially, I'll start with the third-party claim. So,
Okay.
Certainly, and to the extent that I reacted, I apologize, but there has not been a finding by the trial court at all of independent negligence. As your honors know, strict liability by operation of statute is a different consideration entirely. The court did deny the motion with leave to renew. As my colleague said, that those motions are now pending, and certainly we intend to cross-move, and essentially it'll be a relitigation of the indemnity portion of our initial summary judgment motion.
Right.
However, that being said, the basis upon which it was denied, there's been no discovery. There was full and complete discovery. Crown is a defunct entity. There was no witness to produce, and there hasn't been. There has been...
Yeah, but they didn't have an opportunity to sit at EBTs and ask their own questions.
And the court-
They were still entitled to some discovery.
Understood. And
Okay.
the court articulated that. However, in the interim, there have been no other depositions. They didn't need to take any,
Okay.
So while I understand that's not part of this record, I think it's informative. And I just want to make one point on Miglianico and the Mena case, which are the two kind of cases that the trial court's decision really hinged upon. Now, I understand I view it as a distinct issue as to whether or not providing a wedge anchor as opposed to drilling them themselves and having them available. I think that's an issue of whether or not there was perhaps compliance with the statute. However, in theory, with the Miglianico decision...
Accepting that would turn the labor law cases on their head. You are transferring the obligation to the worker. That's precisely why the labor law was enacted.
And that's why I was trying to draw the distinction to not get back into that issue. But in Miglianico, the court said that essentially the fact that the plaintiff was provided a harness and absolutely nothing else, and there was not even one shred of evidence submitted to the court that there was any other method by which this plaintiff could secure the harness was essentially a Halloween costume, right? It was of no utility at all. And what I would argue here is that there is competing evidence as to what was provided. Now, whether or not that was adequate, I think there's the writings on the wall perhaps, but I do think that holding is distinct on that particular issue, not going to the sufficiency of the system.
Okay, thank you.
Thank you.
Ray versus Ray. Last but not least.
May I, Your Honor?
Yes, you may.
Good afternoon, Your Honors. My name is Peter Alkali of the firm of McLaughlin and Stern, representing the plaintiff appellant. Our position, very simple and straightforward. The verdict that was issued by the jury could not have been reached by any fair interpretation of the overwhelming evidence. The overwhelming evidence in this case is that there was an agreement to cover losses. The issue was repeatedly admitted.
Why couldn't the jury find that maybe both parties thought there was an agreement, but they had no meeting of the minds concerning the content of the agreement?
But they had a meeting of the minds, Your Honor. They had a meeting of the minds as admitted really by the defendant. The defendant in this case repeatedly acknowledged the fact that there was an agreement, that she initiated the idea for this arrangement and this agreement. It was her idea.
What they both say is that there was an agreement, but they can't agree as to what the agreement was.
No, they cannot.
So if there was an agreement, counsel, why do you consent to this first question?
There was an agreement to cover losses existed. This was admitted by the fact that even the defendant added language to this agreement called on an
The first question says, did Ames Ray prove by preponderance of the evidence the existence of an agreement to cover losses?
And he absolutely did, because the...
So if that's the question and you're telling us that there is no contest with regards to that, why ask the jury?
Why wasn't it stipulated to?
We considered it to be sort of an elemental part of the building block of the case, Your Honor. This was really, remember, this was a remand.
So you understood that it was something that needed to be proven to the jury?
It was something that needed to be proven to the jury, and it was.
So the jury was then free to reject the argument.
Not in the face of the overwhelming evidence to the contrary.
Except that we have a record, counsel, with all due respect to you, where your client lied multiple times throughout, and not just on irrelevant matters, but on relevant material matters. So based on the jury charges that I recall giving civil juries, a jury is entitled to disregard completely the testimony of anyone that they believe has offered false testimony. And there's no question that your client offered some false testimony throughout the trial.
We obviously dispute that, Your Honor, repeatedly, and we've addressed that statement by statement by statement in our
Right, and
in our
we have a
brief.
record from the federal courts, and we have complaints that he negates, okay? So...
No, Your Honor.
Go ahead.
At the end of the day, if you disregarded every word that Mr. Ray said, there was still an overwhelming evidence that a contract to cover losses existed. This was something that the defendant asked for, negotiated, and signed an agreement, and then, by her own words, executed something and called it by her own words, and executed addendum to the contract. There are repeated admissions throughout this trial that there was a contract to cover losses. Even this court, in remanding the case for a trial on the second cause of action, made it plain that there really wasn't a question as to whether there was an agreement. It wasn't if there was an agreement, it was when the agreement became effective, because that would impact the amount of damages. That was a question relegated to the jury, and that was actually question number 2. But even
Why wasn't that question number 1?
Yeah.
Sorry?
Why wasn't that then question number 1?
Again, we viewed the
Counsel, you had the opportunity and the freedom to object to the judge's proposed first question and say, that's not even an issue here, Judge. I don't understand why we're asking that question. And you could have preserved that issue. But you conceded that by allowing that question to be asked. So as far as I'm concerned, that was an open question for the jury to decide.
And the jury verdict contradicted the overwhelming evidence that a contract to cover losses existed. Whatever the reason was that question became presentable to the jury, the truth here is, and the argument that we're making, is that there's no fair interpretation of the evidence to come to any conclusion other than a contract to cover losses, to the extent the account fell below $350,000, was made and entered into, and the only issue, which was a fact issue, the only issue that we say which the jury never reached, was when did the contract become effective, not if there was such a contract. Putting aside the question of why it was in the jury verdict sheet at all, we viewed it as an elemental part of the remand, because in the second cause of action, there was a denial that an agreement had been made. We viewed this as part of the building blocks of the overall case.
Okay.
And in retrospect, maybe it shouldn't have been presented to the jury at all as law of the case, but at the end of the day, the evidence overwhelmingly established the existence of that contract over and over and over again. Again, an agreement that she herself wanted, negotiated, and signed. So the overwhelming evidence in the case is that an agreement existed. When it existed, that question the jury never reached, but it should not have come to the conclusion that there was no agreement. I do want to say very...
You'll have time on rebuttal.
Thank you, Your Honor.
You may proceed.
Thank you, Your Honor. May it please the court, Matthew Byer, Hush Blackwell LLP, on behalf of defendant, respondent, and cross-appellant Christina Ray. I want to clarify something that was mentioned during my adversary's presentation. I think there is a confluence happening here of all the different agreements and pieces of paper that Mr. Ray coerced his ex-wife into signing. My adversary said that this was an agreement that Ms. Ray wanted, that she advocated, that she negotiated, that was for her benefit. I'm not sure what he's talking about. I'm not sure why Ms. Ray would want to pay Mr. Ray $350,000 that he lost of his own money in his own investment account. Putting aside the preposterousness of that argument, I think, I will be corrected, I'm sure, if I'm wrong, but I think my adversary is mixing the whatever agreement the parties may have had whereby Ms. Ray did operate the trading account and this agreement that he's actually trying to enforce, which is that she would actually pay him back if he lost any money. Plaintiff's position is that the evidence is overwhelming that there was an agreement to cover losses. The evidence that there was an agreement to cover losses is her signature on the page, which is not dispositive. And it's also not been in dispute in the 26 years that this lawsuit has been going on. Mr. Ray is not a believable witness. 2 juries have rejected everything he said. 2 judges, and I'll address this in a moment, but 2 judges have found Mr. Ray's conduct before them to be sanctionable. And I understand that the first sanctions award was reversed by this court. What this trial came down to was 2 people telling 2 different stories. And actually, Mr. Ray provided a few different stories. But with regard to the trading document that's at issue here, Mr. Ray says, Christina signed it because she intended to reimburse me for losses. Christina Ray says, I didn't intend to reimburse him for anything. I signed it because of the 20-plus years pattern of behavior between the 2 of us where he coerced me to sign document after document after document. The jury heard that evidence. They heard 2 witnesses provide different stories about the same piece of paper, and they believed her because she's the only believable person in the case. That's what happened here. And the fact is, as the court has already pointed out, if it was a matter of law that the signature on the page met plaintiff's prima facie burden of proof that an agreement existed, that should have been raised a long time ago. That was not in dispute since at least 2007 when Ms. Ray was deposed. I don't believe she's ever disputed she signed the document. That was almost 20 years ago now.
Counsel, should we sanction?
Yes.
Why?
Because Mr. Ray's conduct in this most recent trial, which I understand is the only one before the court right now, was even more sanctionable, I think, than his conduct in the first trial. The record has been expanded. The briefing includes quite a bit of instances of Mr. Ray outright lying, in my opinion, at the very least, substantially misrepresenting material facts. The 2, I think, most important ones at this trial that did not come up in the first trial are all of his statements regarding the IRS action where he alleged that this whole thing was actually part of a hedge fund that he was trying to create, which is absolutely not true. There's absolutely no evidence to support that other than his own statements because he was trying to get tax advantages. The other, I think, major point in the 2023 trial is Mr. Ray's insistence that he was not in New York in March of 1993 when he, again, coerced Ms. Ray into signing another piece of paper saying that she owed him $500,000. There are other instances, obviously, of factual misstatements. The other thing that was in the record before the court now that was not previously in the record is Mr. Ray's substantial history of pursuing satellite frivolous litigations against Christina Ray.
6 in the last 10 years.
6 in the last 10 years. State court, federal court. He's put her through the ringer.
Kind of like legal abuse?
I would submit that it's legal abuse, Your Honor. He has used this court and the courts of this state and the federal courts of this state to perpetuate an abuse on Christina Ray since 1998, which itself is perpetuating abuse of Christina Ray that goes back at least until the 80s. I obviously wasn't around when they met in the 60s and 70s. I don't want to overstep my characterization of the relationship early on, but I think it's clear that Mr. Ray has been abusing Christina Ray emotionally, mentally, financially for a very, very long time. I'm hoping that that's coming to an end. I would ask that the court reverse the trial court's decision on sanctions and remand it back to the trial court for an entry of judgment. And I would also ask that the trial court be instructed to issue some sort of order enjoining Mr. Ray from continuing to pursue Christina, at least in the New York State courts, so that she can finally, now that she's in her 70s, move on with her life. And unless the court has any questions for me, I'll.
Thank you.
Thank you.
You have 1 minute.
Yes, Your Honor, I'll try to be very quick. First of all, it was far more than just a signature that appeared on the agreement to cover losses. She repeatedly admitted that this was a contract, that she pursued this contract to create a track record to advance her own career. So the motivation for signing that contract went far beyond signature. And that was repeatedly admitted over and over and over again during the trial. As far as
Talk about sanctions, counsel.
yes, Your Honor, and we've addressed the alleged misstatements in our briefs. Mr. Ray has done nothing but pursue a contractual right that he thought he had. He did it legitimately, he did it honestly, and he pursued it with tenacity for sure. And he certainly was prepared to pursue whatever his legal rights were. That was true even of the fraudulent conveyance cases that occurred 15 years after this agreement was executed in a legitimate, valid effort to make sure that there were assets available in the event there was a judgment rendered against her.
Thank you.
There should be. Thank you.